All right, bye-bye.
Never mind.
What's going on, y'all? Good morning.
Good morning. Does anyone have a Kleenex over there? Oh, thank you. My glasses are all foggy. Oh, it's a beautiful dress, Robert. Oh,
No.
we can't do that, Nora. Mhm. Oh, I always have those and then I lose them some sort of way. They end up at the bottom of my purse. That's that.
Rose and Gianni Bell was the clerk's name.
And she has returned.
Yeah, I saw her walking around this morning.
Yeah, just shoot her an email and shoot Rose an email.
All right.
What?
What I think.
Baby Rose.
I know.
Yeah, making sure.
So no. Here's the thing. LaShawn had a good excuse for not showing up at the 5K. Hank, he just overslept. I don't know if that can be counted as a good excuse. Me, I was double booked. So I was at Juneteenth.
I was delayed by one of the super villains that was the subject of the run. The Sandman, you know?
Yeah. All right, everyone, I'm going to call the docket. When I call the docket, if you're here, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not, and a warrant may be issued for your arrest. All right, in custody, we have Anita Herrera, Randy Lee Elizondo, Freddie Garado, Israel Cortez. Thank you. Juan Soto Victorino, custody. George Abaye. Should he be on the docket? We're going to check that out. Sergio Chavez. We need to check the docket and see if they were rescheduled because I'm not sure if Alfonso is still on vacation. Terrence Bowie Jr. Angela Perez. Gabriel Echortia. I pronounced that name correctly and they're not even here to hear it. Veronica Gonzalez, custody. Cassandra Morales. All right, thank you. If I could have the file on that one to make sure I put it in there. Brenda Rodriguez. Chastity Natal. Anthony Cochran.
Here, Your Honor.
Mariano Rendon. Raymond Martinez. I'm sorry. Matthew Rendon. Dondre Scott. David Hancock is in custody. Corian Vallant. Kevin Curiel.
Here.
Vince Ibarra, custody. Gilbert DeLeon. Waverly Whitlock. Okay. Missy Torres. Renee Camarillo, custody. Clinton Camacho, custody. Bobby Rivera, custody. Wesley Mulkey. Portillo is in custody. Victor Garcia. Renee Cantu.
Morning, Your Honor.
Morning. All right, anyone who came in later, your name was not called. What is your name? All right, take a seat on the front row. Anyone else who can, yes, what's your name? I'm sorry,
The plan. We'll talk about the jury.
do you have a case number or SID number? All right, just have a seat. We're gonna see where you are, okay? Anyone else?
Judge,
Yes,
I'm here for Anthony Villarreal. He's outside coming in, but I think we were recalled for today.
all right, Anthony Villarreal. Do you have his case number?
Yes, ma'am, I do. It is going to be.
All right, Belindo Rodolfo. You need to be in county court at law number 2. Everyone, where is county court at law number 2 located?
First floor.
You need to be on the first floor. Yes. If they ask where you were, you can have them call up to the 187. You're welcome. Yes.
That's a 2024 CR 4216.
4216. All right, state, if you don't have that file down, if you can have it brought down, it's 2024 CR 4216.
Requested it, Your Honor.
All right, thank you.
Thank you, Judge.
All right, so everyone, this is how things are going to happen today. As soon as all the jurors are here, state and defense going to do closing arguments on a murder trial that we have. Make sure your phones are on silent, because the worst thing that can happen to an attorney is if they're in the flow of their closing arguments or any type of arguments, and then somebody's cell phone goes off. It's like making somebody be a deer in headlights, which, Vashawn, I did not understand deer in headlights expression until I was driving one night and that deer was in my headlights and it just froze. I'm like, yeah,
They do not move.
they do not move. And then finally he looked at me and he sort of gave me a fist bump and then just hopped across the road. He did a head nod to me. It's like, I see you. But I was terrified that I was gonna hit him.
You hit your car.
So I was just like, really? Really? That's what's gonna happen here? Mhm. Okay. Stuck in traffic on Frio, where they are in constant construction. We'll see what's happening. Yes.
You resent that case to June 27th,
All right, which page is he on?
page 8.
All right, can I see the file for Victor Garcia? Okay. All right, Victor Garcia, if you'll come forward.
Here.
All right, so you're scheduled back here for June 20th, you understand? And you know why you're rescheduled?
June 27th.
Oh, June 27th?
Oh,
No, it's because you missed your TAP evaluation. Yes, if you miss another appointment, what's going to end up happening is, one, I'm either going to go forward on your application without your having done the TAP, or either it's going to be done in custody. Do you understand? When is your TAP evaluation due?
This is the emergency.
No, you need to be sure, because the 27th is when you're coming back to this court, because the TAP is supposed to be completed. Okay, so when is your TAP evaluation?
He's, he did a mistake.
It's for June 20th.
It's felony question. Get intimidated.
All right, here's the thing. Can I get a reset form for him
For my fault.
and put on there June 27th for this court, and then attach a note to him for when his TAP evaluation is due? If you miss your TAP evaluation again, what is going to end up happening is either I'm going to go forward without having reviewed a TAP evaluation, or either you're going to do your TAP evaluation in custody. Do you understand? You have to make these appointments because people have taken off, put other people off their schedule and put you on their schedule. Do you understand? All right, once you sign the reset form, you're excused. You're welcome.
So we're more than likely.
Thank you. So is it already notated in her file? Okay, all right, thank you.
He's not totally crazy, like. You know, batshit crazy. So you just said it 5 seconds ago.
All right, so on this case, have you all had a chance to review the charge?
We have, Your Honor.
We have.
All right, so we're gonna go on the record. Court is calling 2022 CR 4932B, State of Texas versus Oscar Martinez III. Can I have parties announced for the record for the state?
Hank Wilkins and Daniel Escobar for the state, Your Honor.
Defense?
Michael DeLeon for Mr. Oscar Martinez.
And are you Mr. Oscar Martinez? All right, have both parties had a chance to review the jury charge or what's titled the charge of the court state?
We have, Your Honor.
Defense?
We have.
Any objections, state?
No objection, Your Honor. I mean, aside from what we talked about on Friday, that,
All right, any objections to the charge that has been presented?
no objection, Your Honor.
All right, defense, any objections?
No objection.
All right, thank you. So each side will have 40 minutes to argue. And is there a time announcement being requested?
Want a 2-minute? Oh,
I can get 5-minute warning, Judge, at the end.
Okay,
Just 10 minutes.
Can you tell me when I've gone for 10 minutes, Judge?
when you've spoken.
I'm gonna do the baby close, Judge.
All right, so you want a 10-minute time announcement?
Yes, ma'am.
All right, and
2-minute, Judge.
2 minutes. Okay,
All the jurors are here. so
All right.
they're ready.
all right, all the jurors are here? I'm gonna-
Judge,
Yes,
the only thing I'm gonna have them load my PowerPoint.
sure. All right, Randy Elizondo.
Present, Your Honor.
All right, come forward. Hello. Hi, so where are we with the evaluation? I saw that it was completed. Is that that's when his evaluation is scheduled?
No.
All right, is it agreed competency or no? All right, so Norma, recall this after June 27th, because that's when they're having their hearing in Judge Carruthers Court. Yes,
Go back to the 18th.
all right, July 22nd. And that will be your plea deadline date. All right, thank you. Yes, once he signs the reset form. Yes, all right. Could I see Hancock, please?
Sorry about that.
Thank you. And is he on bond? Okay, all right. Deputy Mejia, could you let David Hancock know his case has been dismissed? Mhm. Okay, well, if everybody's here and they want to do it today, I guess we could do it. No, I appreciate it. Just give us a moment. They're setting up their items. All right, parties, are you ready?
We're ready, Your Honor.
Defense, are you ready?
Ready, Your Honor.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, good morning. All right, I hope everyone was able to find parking easily. All right, what I'm going to do now is I'm going to read to you what's called the charge of the court. It's the jury charge. You don't have to memorize it. It will be sent back with you when you begin your deliberations. Charge of the court. Members of the jury. Just one moment. Charge of the court. Members of the jury. The defendant, Oscar Martinez III, stands charged and count one of the indictment with the offense of felony murder alleged to have been committed on or about the 21st day of February 2022 in Bexar County, Texas. The defendant, Oscar Martinez III, stands charged in count two of the indictment with the offense of felony murder alleged to have been committed on or about the 21st day of February 2022 in Bexar County, Texas. The defendant, Oscar Martinez III, stands charged in count three of the indictment with the offense of aggravated robbery alleged to have been committed on or about the 21st day of February 2022 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of felony murder if he commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt, or in an immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Robbery is a felony offense. 2. Our law provides that a person commits the offense of robbery if, in the course of committing theft, as defined below, and with intent to obtain or maintain control of the property, he intentionally or knowingly causes bodily injury to another, or he intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. 3. A person commits aggravated robbery if the person commits a robbery as defined above and uses or exhibits a deadly weapon. 4. A person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of such property. Appropriation of property is unlawful if it is without the owner's effective consent. 5. Individual means a human being who is alive. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in immediate flight after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Property means tangible or intangible personal property, including anything severed from land, or a document, including money, that represents or embodies anything of value. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Effective consent includes consent by a person legally authorized to act for the owner. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the actor. 6, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 7, law of parties. Our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if, 1, acting with the kind of culpability required for the offense, he causes or aids an innocent or non-responsible person to engage in conduct prohibited by the definition of the offense, or 2, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. You are instructed that in a prosecution in which an actor's criminal responsibility is based on the conduct of another, it is no defense that the person for whose conduct the actor is criminally responsible has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense or of a different type or class of offense, or is immune from prosecution. 8, you're instructed that an accomplice witness, as that term is herein used, means any person connected with the crime charged as a party thereto, and includes all persons who are connected with the crime by unlawful act or omission on their part transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the offense. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission. If you believe from the evidence beyond a reasonable doubt that an offense was committed, and you further believe from the evidence that the witness, Jeremy Martinez, was an accomplice, or you have a reasonable doubt whether he was an accomplice, as that term is defined in the foregoing instructions, then you cannot convict the defendant upon the testimony of Jeremy Martinez unless you first believe that the portion of the testimony of Jeremy Martinez which ascribes guilt to the defendant is true, and that it shows the defendant is guilty as charged in the indictment. And even then, you cannot convict the defendant unless you further believe that there is other evidence in the case outside of the evidence of Jeremy Martinez tending to connect the defendant with the commission of the offense charged in the indictment. And then from all the evidence, you must believe beyond a reasonable doubt that the defendant is guilty. If you believe from the evidence beyond a reasonable doubt that an offense was committed, and you further believe from the evidence that the witness, Jerry Ortiz, was an accomplice, or you have a reasonable doubt thereof. Sorry, just one moment. Can I have parties approach? If you believe from the evidence beyond a reasonable doubt that an offense was committed, and you further believe from the evidence that the witness, Jerry Ortiz, was an accomplice, or you have a reasonable doubt whether he was an accomplice, as that term is defined in the foregoing instructions, then you cannot convict the defendant upon the testimony of Jerry Ortiz unless you first believe that the portion of the testimony of Jerry Ortiz which ascribes guilt to the defendant is true, and that it shows the defendant is guilty as charged in the indictment. And even then, you cannot convict the defendant unless you further believe that there is other evidence in the case outside of the evidence of Jerry Ortiz tending to connect the defendant with the commission of the offense charged in the indictment. And then from all the evidence, you must believe beyond a reasonable doubt that the defendant is guilty. You are further instructed that if you find beyond a reasonable doubt that both Jerry Martinez and Jerry Ortiz are accomplices, as instructed herein, they cannot corroborate each other. Corroborative evidence tending to connect the defendant with the commission of the offense charged in the indictment, as instructed above, if any, must be from some source other than from the testimony of anyone who you find to be an accomplice. 9, count 1, felony murder of Enrique Bocanegra. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of February 2022 in Bexar County, Texas, the defendant, Oscar Martinez III, either acting alone or together as a party with another, did then and there commit or attempt to commit the felony offense of robbery, and while in the course of and in furtherance of the commission or attempted commission of the felony offense of robbery, or in immediate flight from the commission or the attempted commission of the felony offense of robbery, Oscar Martinez III, either acting alone or together as a party with another, did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, discharging a firearm at or in the direction of Jerry Ortiz and thereby causing Jerry Ortiz to discharge a firearm, thereby causing the death of an individual, namely Enrique Bocanegra. Then you will find the defendant, Oscar Martinez III, guilty of the felony murder of Enrique Bocanegra as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Oscar Martinez III, not guilty of the felony murder of Enrique Bocanegra as charged in count 1 of the indictment. 10, count 2, felony murder of Christopher Mejia. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of February 2022 in Bexar County, Texas, the defendant, Oscar Martinez III, either acting alone or together as a party with another, did then and there commit or attempt to commit the felony offense of robbery, and while in the course of and in furtherance of the commission or attempted commission of the felony offense of robbery, or in immediate flight from the commission or the attempted commission of the felony offense of robbery, Oscar Martinez III, either acting alone or together as a party with another, did then and there commit or attempt to commit an act clearly dangerous to human life, to wit, discharging a firearm at or in the direction of Jerry Ortiz, and thereby causing Jerry Ortiz to discharge a firearm, thereby causing the death of an individual, namely Christopher Mejia. Then you will find the defendant, Oscar Martinez III, guilty of the felony murder of Christopher Mejia as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Oscar Martinez III, not guilty of the felony murder of Christopher Mejia as charged in count 2 of the indictment. 11, count 3, aggravated robbery. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of February 2022 in Bexar County, Texas, the defendant, Oscar Martinez III, either acting alone or together as a party with another, while in the course of committing theft of property and with intent to obtain or maintain control of said property, did intentionally or knowingly threaten or place Jerry Ortiz in fear of imminent bodily injury or death, and Oscar Martinez III, either acting alone or together as a party with another, did use or exhibit a deadly weapon, to wit, a firearm, then you will find the defendant, Oscar Martinez III, guilty of the offense of aggravated robbery as charged in count 3 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of count 3. As you were instructed during the trial, to ensure that the jury, the court, and the parties are all receiving the same testimony, a witness who does not speak English utilizes the services of an interpreter when testifying. You are instructed that you, as the jury, are to base your deliberations on the questions posed to that witness as they came from the attorneys in the English language, and on the responses from the witness as they came from the interpreter in the English language. You are instructed that if there is any evidence before you in this case regarding the defendants having committed an act or acts of misconduct other than the offenses alleged against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such acts or acts of misconduct, if any were committed. And even then, you may only consider the same in determining consciousness of guilt, if any, of the defendant in connection with the offense in this case and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone any information or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Off the record for a moment. Excuse me, y'all are going to have to find a seat. All right, we're back on the record. Written statements made by witness to investigators or other officers, or police reports made by officers and tendered by the prosecution for the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience, if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas. All right, state, are you prepared to proceed?
We are, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Good morning. We as the state, we carry the burden in this case. So we get to speak to you first, we get to speak to you last. So I'm going to speak to you about some of the law that the judge just gave you and that you just read into the court, into the transcript. And then Mr. DeLeon will get the opportunity to speak to you. And then Daniel will get the last opportunity to speak to you before you go back there and deliberate. So this is a pretty lengthy document. This has all the law that you need to decide this case. And one of the first questions jurors have when they go back there, sometimes they send a note out that's like, hey, I want to see that police report that Officer Richmond was referring to. And unless it was entered into evidence, you won't have that back there. So all you're going to have back there is the evidence that was entered in this case. And I want to talk to you about the oath that you took. Part of the oath that you took as jurors is not to let bias, prejudice, or sympathy play any role in your deliberations or in the verdict that you reach. And so there's no but here. There's no, well, I believe the defendant is guilty, but I feel bad for him. And you are deciding punishment in this case. The jury is going to decide punishment in this case. And so if you feel any sympathy for the defendant, the time for that is in the punishment stage of the trial. This is right now, all y'all are to decide is guilt, innocence. So I want to talk to you about the law of parties. Daniel talked to you about this last week in jury selection. And the law of parties in the state of Texas, and it's in your jury charge, but I want to go over it with you. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the person to commit the offense. And that can be before, during, or after the commission of the offense. And so what does that mean? I mean, we talked about it at jury selection, but it's the convenience store example, right? You and your buddy, you go to rob the convenience store, he's got a gun, you don't have a gun, he shoots the clerk. You're on the hook for that. That's the law of parties in the state of Texas, and that's what's in your jury charge. And so count one in this case is the felony murder of Enrique Bocanegra. And I've highlighted the important parts of this. Oscar Martinez, acting alone or together as a party with another, did then and there commit the felony offense of robbery, while in the course of commission or attempted commission or in immediate flight, did then and there commit an act clearly dangerous to human life, discharging a firearm at or in the direction of Jerry Ortiz, and thereby causing Jerry Ortiz to discharge a firearm, thereby causing the death of Enrique Bocanegra. And so the important part here is commission or attempted commission. So we heard testimony during the trial that Chris gets out of the vehicle with the gun. And you see in here and you see in the charge of the court, discharging a firearm at or in the direction of Jerry Ortiz. But it's commission or attempted commission. So once Chris gets out of that car with the gun, it doesn't matter whether he gets the shot off or not, okay? And so that's count one, the felony murder of Enrique Bocanegra. Count two, the felony murder of Christopher Mejia. And they're very similar. But Oscar is responsible for the conduct of the other people in that car that day. And I want to point out to you, in both of these counts, count one and count two, it's commission or attempted commission. And then count three is aggravated robbery. Oscar Martinez, acting alone or together as a party with another, while in the course of committing theft of property, did intentionally or knowingly threaten or place Jerry Ortiz in fear of imminent bodily injury or death. And Oscar Martinez, either acting alone or together with another, did use or exhibit a deadly weapon, to wit, a firearm. And so that's part of party language, right? So he's responsible for the other folks in that car. So the other folks in that car have a firearm. Doesn't matter whether Oscar had a firearm in his hand or not. He's responsible for their actions because of the law of parties in the state of Texas, which is in your jury charge. I want to talk about accomplice witnesses. So what this says, this is in your charge too. You cannot convict solely on accomplice witness testimony. Accomplice testimony must be corroborated by other evidence that connects the accused to the offense. But all the law requires, this is the highlighted portion, all the law requires is that there be some non-accomplice evidence which tends to connect the accused to the commission of the offense. That's all the law requires. And so on this slide, this is all the other evidence that you had in this case. So the testimony of both the police, the CSIs, the medical examiners, Ms. Atkinson, the photos, the videos that you saw, the shell casings, the bullet that the medical examiner removed from Enrique Bocanegra, the guns, the forensic testimony, the diagrams, the documents, and the scientific reports. These are all separate and apart from any accomplice witness testimony in this case. And while we're talking about testimony, I do want to talk to you about a couple of the witnesses. We had to bring Christopher's mother here to testify, and we had to bring Enrique's daughter here to testify. And those were very brief witnesses. And I just want to tell you the purpose of that is one of the things we have to prove is that these people died. And so I know that was difficult and we tried to make that as brief as possible, but I wanted to tell you the purpose of that is we have to bring those witnesses to say, this is my family member, this is my loved one, and they're dead. But the purpose of that was for their identification. So this is in your charge. This is defense is excluded. And the actor may be convicted on proof of commission of the offense and that he was a party to its commission. And it's no defense that the person for whose conduct the actor is criminally responsible for has been acquitted, has not been prosecuted or convicted, has been convicted of a different offense, or is immune from prosecution. So that's the law in the state of Texas. Oscar can't hide behind, well, hey, wait, this other guy didn't get prosecuted. Or somebody else, there were a couple juveniles in the car. They were held to a different standard than I was. You can't hide behind that. You can't use that as a shield. And on that same note, I want to talk to you about witness credibility. It's in the jury charge. Y'all, as the jury, are the judges of the credibility of each and every witness. So you get to judge the credibility of the police witnesses, the CSIs, the medical examiners. And you're also the judge of the credibility of Jeremy and Jerry. And I don't expect you to love the way they testify or to love the choices that they made in this case. But I want to remind you that Jeremy and Jerry are not on trial here. Oscar Martinez is on trial. We're asking you to use your common sense when you're back there deliberating. We're asking you to remember the testimony that you heard, to examine these videos, photos again, look at all the evidence that was brought forth, and to hold the defendant responsible and accountable. We're asking you to hold Oscar Martinez responsible for his actions and accountable for his actions. We're asking you to find Oscar Martinez guilty of the murder of Enrique Bocanegra, guilty of the murder of Christopher Mejia, and guilty of aggravated robbery. Thank you. Your Honor, I reserve the rest of our time.
Thank you.
Yeah, proceed, Your Honor.
Yes.
Ladies and gentlemen, on behalf of Oscar, Oscar's family, and myself, I want to thank you for your service as jurors. We know that you're taking this case very seriously, and this is a very serious and important case to Oscar and his family. The state of Texas has the burden in this case to prove this case to you beyond a reasonable doubt. The state has not proven their case beyond a reasonable doubt. In jury selection, we talked about many things, but you came into jury selection. You found out this was going to be a murder case. We said, or at least I said, keep an open mind here. And when this case started last week, you probably had an idea, well, this case is probably about this. But now, 1 week later, you have all the facts in the case. This case was not what you thought it was going to be, okay? Let's deal with what we know, not with what we don't know. What we know is that Oscar Martinez did not murder anyone. factually, he did not murder anyone. We know that Oscar Martinez, there's no evidence that that he ever handled a firearm. All right, no evidence he shot a firearm. His fingerprints are not on any weapons. His actions show he stayed at the scene. He didn't flee. He called his mother on the phone when he was at the scene. And I'll rephrase that. This 19-year-old kid, I'm going to call him a kid, even though he's legally an adult. This 19-year-old kid called his mommy on the phone when he got in trouble. And seeing his friend dead on the ground out there in a gunfight that happened, yeah, he was scared to death, but he still stayed at the scene. He did not put the guns in the blue recycle bin. That wasn't him. And he answered police officers' questions at the scene. You saw the body cam of the officer, and he gave his name, address, started saying what was going on. He told Detective Morales in that interview that Christopher and Joshua came up with this plan to take Jerry Ortiz's marijuana. All right? That's what it boiled down to. In the videos, you'll see in the video, when Christopher Mejia got out with that gun, Oscar did not follow him. Why? Because Oscar had no clue Christopher Mejia was going to get out of the truck with a gun in his hand. He had no clue that was going to happen. Oscar didn't drive the truck forward. He was helping Joshua, who had been shot. And you see him twice go up to Christopher. And there's different videos out there. You see him twice go to Christopher and touch him while he's on the ground, trying to assess. And if you look at Christopher, you're probably thinking at the time, this is not good. He doesn't look alive. But there's twice where Oscar touched Christopher. We talked about in jury selection, teenagers make mistakes. All right. And in this particular case, Oscar made a huge mistake because he was hanging with the wrong crowd. The Mejia brothers, the 4 Mejia brothers. He was hanging with them. And if you hang with the Mejia brothers, you're going to end up in trouble. All right. The Mejia brothers had guns on them. We know that now. The Mejia brothers had weed on them. The Mejia brothers had contacts who know someone who sells marijuana, hence Jerry Ortiz. Joshua and Christopher Mejia thought that this would be a good idea. Now the burden to prove. The state has the burden to prove this case to you beyond a reasonable doubt. We talked about that many times in jury selection. The defense doesn't have to prove anything to you. We did bring some evidence forward to you in the form of the defense exhibits 1 through 6. Beyond a reasonable doubt. We talked about the highest standard out there that the state has to prove to you. Now in the jury charge, we do want you to focus on the elements in counts 1, 2, and 3. Evidence to prove it to you beyond a reasonable doubt. Now, maybe, could have, possibly, more than likely. Built in those phrases is doubt because it's not for sure. All right, possibly, maybe, could have. That's not enough. All right, and the state is asking you to guess on a lot of these different elements. All right, remember, we'll come back to that in a second. But you all agreed you would hold the state to their burden of proving the case beyond a reasonable doubt. So law of parties, essentially, they need to prove that a felony occurred and that a death occurred during that felony, and then you have felony murder at that point. So credibility of the witnesses, you're the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. As you know, Judge Boyd handles the law. The 12 of you are judges of the facts. All right, you determine what the facts are. With law of parties, as you see in the jury charge on page 6, and you'll have a copy of this back there in the jury room with you. On law of parties, mere presence alone will not make a person a party to an offense. All right, you heard Detective Morales say that as well. Mere presence alone is not enough. Just because he's hanging with the wrong crowd is not enough to get him convicted of aggravated robbery or felony murder. All right, you need more than that. And if you look at, I kind of summarize it, need a plan or a scheme or something, but here, it states right here, that acting with intent to promote or assist the commission of the offense, the state alleges that's aggravated robbery, Oscar solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. All right? With Oscar, is there any evidence that Oscar solicited this drug transaction to go through? No, there's no evidence. In fact, we know from Jerry Ortiz, he says that Joshua Mejia, the driver, I recognize him from his Instagram photo. They were talking on Instagram to set up a meeting to buy this marijuana. All right? That's not Oscar. Encourages. Is there any evidence Oscar encouraged anyone to do this aggravated robbery? None. All right? Directs. There was no. Jerry Ortiz stated specifically, and I'll go through it again. He never said, Oscar said, do this. Oscar told others to do that. Never happened. Aids or attempts to aid. Once again, where's the evidence that Oscar did any of that? It's not there. So, remember in jury selection how we talked about all these hypotheticals and convenience stores and things like that? The consensus was this is a gray area. It all depends, right? Facts matter. Evidence matters. And now that you have all the facts, all the evidence, it's your time to judge those facts. All right? So what evidence is there that Oscar knew about the plan to commit the robbery? All right? He was there, but Detective Morales told you, mere presence alone is not enough. He overheard this plan by Joshua and Christopher right before it happened. All right? They were at the gas pumps for about 1 minute and 15 seconds. All right? And then they moved over and drove up to where Jerry Ortiz came out and talked to him. Not a lot of time. No evidence that Oscar knew that Joshua had a firearm. There's no evidence that he knew that Christopher had a firearm. There's no evidence that he knew Christopher would go after Jerry Ortiz, get out of the Suburban with the firearm. He didn't know that. All right? There's no evidence of that. This was not some well thought out plan. All right? There was no evidence this plan was conceived with Oscar's knowledge until it had already begun. Last minute conversation, and Oscar was hanging with the wrong crowd. He's there in the Suburban. He's overhearing it as it's happening. Let me tell you what is not your job as jurors. Filling in the multiple holes for the state's case is not your job. It is their job to prove this case to you with evidence beyond a reasonable doubt. When you go back to the jury room, it's not your job to say, well, if we think about it, maybe the police could have done this or that or the other, they would have found this. No, your job as jurors is to evaluate the evidence that's presented to you. If the state's case has holes, which it has many holes, it's not your job to do their job for them, okay? The state must prove that case to you beyond a reasonable doubt. If they fail, you must vote not guilty by law. Let's talk about witnesses. Overall, during the case, I didn't have almost any objections to 90 pieces of the state's evidence. And why is that? Because regardless if it was evidence collection, manner of death, lay witness statements, videos, all of them point to Jerry Martinez killing 2 people. All of that evidence points to that. All of that evidence does not point to Oscar Martinez at all. Let's talk about the recovery of the weapons. Now, 3 guns found in the blue recycled bin. All right, guns put there by Juan Mejia. We'll talk about him in a second. One gun, the Ruger SR-40, was fully loaded at the time. 14 rounds in the magazine and 1 in the chamber. All right, that's a fully loaded gun. Now, it seems like maybe that gun was used and then somehow someone went and fully reloaded it and then it was picked up and put in the recycle bin. Is that likely? I mean, is it possible? Sure, it's possible, but why would they do that? All right. It seems like that gun was not used at all during the commission, okay? The Glock 40 caliber had 1 bullet left, meaning 14 bullets were missing from it, up to 14. All right. That gun was more than likely Christopher Mejia's gun that was eventually shot maybe once by Christopher, but then somebody else picked up that gun and kept on firing. All right, so definitely we know that gun was used for sure. The 380 caliber had 3 live rounds with an extended clip. However, we know that the shell casings, there was only one 380 shell casing found at the scene. So probably that gun wasn't used all that much, if at all. I mean, sometimes the police might not find every shell casing. I think they do their best, but there wasn't a ton of shell casings like the 40 caliber shell casings. And on video, we see Juan Mejia has a gun in his hand. All right, we know he handled it. And there's shell casings at the scene. So on video, you see Juan Mejia, age 15, dressed in the black shirt, the faded blue jean shorts with holes, with the guns in his hand, putting the guns in the recycle bin. That's on the video. You see on the right-hand side is Juan Mejia, black cap, black shirt, blue jean shorts. You also see on the left side, Juan Mejia with a gun in his hand after Jerry Ortiz took off running. All right. And then, you know, Jeremy Martinez, the shirtless Jeremy Martinez, because he testified in court to you. He's 15 now, but he was 13 back then. Gunshot residue. I want to talk about gunshot residue, not because it's all that important at all, but just I want to touch on it. I don't want you thinking in the jury room that somehow it was important. It's not important. The forensic scientist, Miss, what we call her, Shopi, said everybody had GSR on their hands. Not unusual if you're having a pretty close area with 20 plus shots going off. Everybody should have GSR on their hands. All right. It makes no difference if it's 1 microscopic particle or 3 or 6. That's what she told us. Okay. And she used the phrase over and over again. A person may have discharged a firearm, handled a discharged firearm, or was in close proximity to a discharged firearm. And that's what we're dealing with here. With Oscar and everyone else there in the Suburban, they all had GSR. Even Christopher Mejia, okay, had GSR. Oscar was next to Joshua, the driver, who had shell casings, 4 shell casings at his feet. It's possible that Joshua, the driver, was firing through the Suburban right past Oscar, and Oscar could have had GSR put on. Remember the LeBron James powder? Well, that's flying through the Suburban. All right. It's also possible, remember I talked a while back, Oscar went to Christopher on video, touched him twice. You can have transference. If he had GSR on him, when he's touching him, moving him, he can get GSR on him as well. In the end, it really doesn't make any difference. Everybody should have GSR on him because they were all in close proximity to 20 shots being fired. Let's talk about Jerry Ortiz. He admits his bullets killed Christopher Mejia and Enrique Bocanegra. There is no doubt that Jerry Ortiz is the one who killed those 2 individuals. All right, no doubt. Nobody disputes that. He admits he was selling marijuana and it was illegal, and he brought his 40 caliber weapon with him that he thought was cool. All right. He admits the person he recognized from the Instagram was the driver, Joshua Mejia, not Oscar. He admits he threw his gun away after the shooting. He admits he returned to the crime scene, his home, looked out the window, still didn't cooperate with the police. He took off. All right. He only went to the police station hours later, and then still didn't tell Detective Morales anything at that point. He admits his phone was never collected by the police. He doesn't know if Oscar fired a gunshot at him. He said that. He's like, I don't know if Oscar did anything. He admits Oscar didn't tell anyone to fire at him. Jerry Ortiz does say that Joshua, the driver, told Christopher, just shoot him. All right. He admits Oscar didn't direct, command, or tell anyone to take him or take anything from him. Now, here's the problems with Jerry Ortiz. Jerry Ortiz is a mess. All right. Jerry Ortiz can barely answer questions from the state and from the defense. All right. Jerry Ortiz's perception is flawed, to say the least. We talked about the window not being rolled down, and you're gonna have Jerry Ortiz's statement, and we'll talk about the window in a second. But Jerry Ortiz says he went up to the green Suburban. He looked back and there were 5 to 6 people in the green Suburban. He said they all had guns pointing at him. Once confronted about the number of guns recovered, his answer changed. Suddenly it was, oh, well, maybe it felt or seemed like everybody was pointing guns at me. He was so sure at first every single person had a gun. And then it changed to, well, it seemed like everybody had a gun. Just perception, all right? His recollection comes from a statement he made 10 months after the shooting occurred with the district attorney's office, all right? And today, that statement is 18 months old, all right? So 10 months, if you have to remember something that happened 10 months ago, which would be roughly, I don't know, September, October, would you get every detail right? Probably not. And same with Jerry Ortiz. He's writing it the way that he recollects it. Who knows how that has changed over 10 months and now later another 18 months. And he said when he went up to that window, guns were instantly pointed at him and everybody yelled, "Give us what you got," or something along those lines. Give us everything you got. Let's talk a little about Jerry when he went up to the car. He says he showed up and instantly he saw that Oscar had a long rifle pointed at his chest. He was literally this close, even closer, this close to the Suburban. And he sees a long rifle pointed at his chest. All right. Oscar is right-handed. All right. The air rifle was located in the back of the Suburban. We verified that. Air rifle found in the back. There was no clip in this air rifle. All right. And see the video. The video, it tells you so much. You got to remember in that video. Well, let's talk about this. Jerry Ortiz is lying to you. All right. At 14:27:31 seconds, and you see the 14:27:31 timestamp on the video. That's when Jerry arrives at the window. Remember what he testified to you. He said, when I got there, they all pulled guns. They all started saying, "Give me everything you got." All right. But if we look at the video, and you can look at the video again. Once again, Jerry said he saw Oscar with a long rifle pointed at his chest, right there. All right. Now, instinctively, when that happens, what would you do? If you go, whoa, dang, you put up your hands, you step back a second and go, geez, take it easy, right? That's what any human being would do. See that big rifle? Whoa. That's what would happen. Jerry Ortiz told you that's what he did, all right? If you look at the video, that's not what Jerry Ortiz does. At 14, we started at 31 seconds, all right? At 14:27:33, Jerry's still talking. He hasn't raised his hands. He hasn't stepped away. At I'm gonna say 35 seconds, still talking. 38 seconds, still talking. 40 seconds, still talking. It's at 45 seconds where he finally throws his hands up. And it's difficult to see from that picture, but in the video, you'll see at 45 seconds, he throws his hands up. All right. 14 seconds after he showed up at that window. And I questioned him directly about it. And he was for sure telling you under oath, as soon as I got to that window, that's when they pulled the guns on me. That's when they started screaming, "Give us everything you got." Not true. Not true. Oscar, in describing the shooting, was talking with the detective. You can see him using his right arm. You can see him using his right hand, talking about bullets flying. You can see him drinking water with his right hand. Maybe in court, you've seen him write with his right hand. He's right-handed. All right, let's talk a little bit about the window. If, according to Jerry Ortiz, this weapon if Oscar was there and he's right-handed, he'd have to have his right finger over here and move kind of like this towards the window. Not really comfortable. Is it possible? Sure. Not the best. Maybe if you're left-handed, that goes a little bit better. But once again, if this weapon is pointed at 1 foot away from your chest, you're going to instantly throw your hands up and just back up a sec. That's what you're going to do. Jerry Ortiz told you that's what he did. 14 seconds goes by. He's not remembering the truth correctly. He's not telling you the truth. Once again, Jerry Ortiz told you he only had 10 grams of marijuana. The police find 20 grams. He says he found a 40 caliber semi-automatic gun in Kenwood Park. Is that possible? It's possible. We'll never know for sure. But is it likely you're going to go and find a $400 to $800 semi-automatic weapon lying around in a park? Maybe, maybe not. We don't know. I think Jerry is, doesn't want to say how he got a gun. He wants to kind of say, oh, it was just so innocent. I just found it. The window is cracked a little bit. In his statement, which you'll have in defense exhibit number 4, maybe 3, you'll see that JO is Jerry Ortiz's initials. He talks about, this is a little thing, but he had originally wrote in a statement, the passenger window was cracked a little bit. Okay, cracked. And then he says, no, it was rolled down all the way. He made a correction, open all the way. If you look at the video, there's 3 or 4 inches of glass. Okay. He's not correct in his perception about how he views things. He also stated in his statement that he sold weed more than once. All right. This is not his first rodeo. And this is only him admitting to one time previously he sold marijuana. But when he testified to you, he testified differently. Jerry Ortiz is also lying to you because he testified under oath to the 12 of you, the 13 of you, that he did not ask his girlfriend's younger brother, Harley, to be a lookout or to cover him or anything like that. I don't believe in coincidence, folks. Here, this kid who's maybe 8, 10 years old is coming out with a 40 caliber semi-automatic weapon. In the video, it's grainy, but you can see the kid, as you hear arguments starting to occur within view of him, he's racking the slide back. This kid is racking the slide back. And when he starts hearing more trouble, I think a gunshot starts going off, the kid goes forward, towards the area. All right? It's gated off, but he goes forward. We heard from Detective Morales that he found this kid. And the kid testified that, yeah, he was there. He had 40 caliber, and he took a shot into the ground, allegedly. All right? Coincidences. I don't think that a kid is going to come out with a 40 caliber gun, and we know whose 40 caliber that is. That's Jerry Ortiz's mother's gun that was registered to her, registered to this house. I don't think a kid's going to come out with a 40 caliber unless he's asked to by Jerry Ortiz. All right? That goes to Jerry Ortiz's credibility. That goes to his, here he is testifying to you that, oh no, I would never do that. I would never ask a kid to do that. And Detective Morales, I mean, at least he found this kid. I think Detective Morales says, I don't know how old he is. I never found out. But here we are with a kid with a 40 caliber, directed by Jerry Ortiz. And we all know, and we'll talk a little bit more about this, that Jerry Ortiz made a deal with the district attorney's office. We'll talk more about that in a little while. Accomplice testimony. You're going to have in the jury charge language that tells you several things. When you're back there, you're going to have to read this for yourselves, all right? Or at least read it out loud to the group. All right? As the judge wrote to you, you're instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness's testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness testimony is corroborated by other evidence. All right, what does that mean? It means if you listen to Jeremy Martinez up here and you go and you say, you know what? Jeremy Martinez testified. I believe Jeremy Martinez beyond a reasonable doubt, which no one should. All right, at least on certain things. I believe him beyond a reasonable doubt that Oscar was part of this aggravated robbery. All right. Even then, even if you believe it, you need further evidence before you can convict Oscar Martinez. All right. And you can't rely on Jerry Ortiz, another accomplice, to back up Jeremy Martinez, and vice versa. If you believe Jerry Ortiz, you have to believe him beyond a reasonable doubt. And even if you do believe that Oscar Martinez is guilty of aggravated robbery, you still need corroborating evidence, and it can't be Jeremy Martinez. All right, you need something else beyond that. And that's laid out on page 8, 9, and 10. It's kind of long, but read through it and you'll know that if you go through that, there's nothing beyond either Jerry Ortiz stating Oscar was involved or Jeremy Martinez stating Oscar was involved. And we'll talk more about those two individuals in a second. For accomplice testimony, you have to not only believe and rely on Jerry Ortiz's testimony or Jeremy Martinez beyond reasonable doubt, but you also need corroboration, and it can't be either one. All right. Oscar being there is not enough. Mere presence alone is not enough. The state brought you another witness that they want you to believe, and that's Jeremy Martinez. Jeremy, shirtless Jeremy at age 13 at the scene, said that Oscar, out of the blue this comes, we've never heard this before. Oscar had a pistol, and this was all Oscar's idea. All right. Jeremy said that the airsoft rifle, which is this, was in the back of the Suburban, and it was found in the back of the Suburban. He told you that Oscar asked for the shoes. He told you that Oscar was shooting the gun. He said, I never saw any guns in this Suburban. All right. Jeremy also said Oscar moved to the driver's seat to apparently leave or take off, which never happened. And in the videos, you'll never see Oscar inside the driver's seat trying to take off. And Oscar asked somebody, I think him or somebody else, to get rid of the guns. All right. All Oscar, of course, he, Christopher, Juan, and Joshua were all innocent. They were just completely innocent of any type of bad act. Jeremy says his brother Joshua was wrongfully convicted. He said that in so many words. All right. Jeremy says nobody from the backseat asked for anything. Jeremy says Joshua, the driver, never asked for anything, never pulled a gun. Jeremy forgets the answers he gave to prosecutors only the day before. Jeremy forgets the answers he gave to the prosecutors 10 minutes before I questioned him. We heard nothing but a lot of, I don't know, I don't know, I don't know, I don't remember, I don't remember, I don't remember. It was bizarre, to say the least. All right. So these two state witnesses contradict each other. They contradict each other. The state wants you to believe Jerry Ortiz, but they also want you to believe Jeremy Martinez at the same time. Their testimonies conflict. They don't corroborate each other. In fact, they contradict each other. So there is no corroboration that Oscar Martinez was active in this aggravated robbery. Detective Morales. Now, SAPD, the evidence text, did not bother to fingerprint the airsoft rifle. That might have been helpful. Once again, it's not your job to do the police's job or the DA's job. They didn't provide you that evidence. They didn't provide you that evidence. Detective Morales admits they messed up the DNA analysis of evidence. He admits he never even reviewed relevant videos of the crime until the trial started. 2.5 years later, he is now reviewing various videos. He interviews Oscar, and during that interview, Oscar tells Detective Morales, remember, this is the night of the shooting, okay? Detective Morales doesn't know Jerry Ortiz's version. He barely knows who Jerry Ortiz is at that point. He did not see the neighbor videos. He didn't see officer body cams. He doesn't know any GSR analysis. He doesn't know where the shell casings came from. He doesn't know anything about ballistics at that point. He does not know the Instagram discussion of buying marijuana between Jerry and Joshua. And what does Detective Mark Morales do? He charges everyone with capital murder. Everybody goes down for capital murder. Joshua, Juan, Jeremy, Oscar. 2 days later, Jerry gets capital murder charges. Basically, let's charge everybody. We'll figure it out later. We know that Joshua was sentenced to prison for murder. Juan is a juvenile. State didn't bring you any evidence about his case. Jeremy, juvenile, charges dismissed. Jerry Ortiz, he made a deal, charges were dismissed. Oscar, we have the jury trial right now. When Oscar is charged, the detective has no idea that Oscar allegedly had a weapon. All right, he didn't hear that until 10 months later when Jerry Ortiz is at the DA's office making a deal at the time and says, and has a motive to get the heat off of him, says it was Oscar and everybody else in that Suburban. They're the ones who did it, not me. I call that a rush to judgment. The police made a rush to judgment. We have to find out who did this, so everybody gets charged. In court, Detective Morales told you specifically, this air rifle is not a deadly weapon. Not a deadly weapon. It's not a firearm. This clip wasn't even found. It's a pellet gun, a glorified pellet gun. Not a deadly weapon. The state has to prove to you in an aggravated robbery that a deadly weapon was used. That's not a deadly weapon. So if you believe Jerry Ortiz's statement that Oscar was holding this rifle, remember the whole 14-second thing, but if you believe that, that's not a deadly weapon. They have to prove a deadly weapon to you. And a deadly weapon is defined in the jury charge. It means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. We don't have that. This is the law. All right, you have to follow the law. The state did not prove to you a deadly weapon in this aggravated robbery. And if he's not guilty of aggravated robbery, which he's not, there's no deadly weapon, all right, unless you believe Jeremy Martinez's bizarre Oscar had a pistol and nobody else had anything else story, which highly, I mean, who could believe Jeremy Martinez on that? Unless you believe Oscar had a pistol and was directing everything, that's the only way you could possibly find him guilty of aggravated robbery. But here, Jerry Ortiz is saying that somehow is a deadly weapon, a firearm. It's not. So if he's not guilty of aggravated robbery, then he cannot be found guilty of murder because no felony has occurred. All right, try to follow me with that. If you didn't do the aggravated robbery, if you're not guilty of that because the state didn't prove it beyond a reasonable doubt, then you can't be guilty of murder. You can't be guilty of murder. The real killer goes free. The district attorney's office dismissed charges against Jerry Ortiz. Jerry admitted his bullets killed 2 people, and the DA's office knows Jerry Ortiz is conducting a drug transaction, an illegal drug transaction, and then they go out of their way to say, we're going to let you have self-defense. The DA didn't bother to bring you Assistant District Attorney Lauren Glasscock, whose name is on that proffer document. They didn't bring her in to explain why were these charges dismissed, Ms. Glasscock. Detective Morales told you he talked to Ms. Glasscock. When I asked Detective Morales specifically, why is it that Jerry Ortiz, as a drug dealer, gets the benefit of the law for self-defense? Detective Morales could not answer that question. He did not answer that question.
5 minutes.
So the real killer goes free. Jerry Ortiz makes a deal. And the prosecutor might tell you, well, there was no agreement to dismiss. It was only a proffer agreement. Folks, let's deal with reality. When you come to the DA's office with capital murder charges and your attorney on December 15th, and your case of capital murder is dismissed on January 4th, that's a good deal. That's a sweetheart deal. It's a fantastic deal. If it wasn't for Christmas and New Year's, it might have been dismissed in 2 days. So don't tell me that that's not a deal. The DA is giving out immunity agreements to everyone. Jeremy Martinez got an immunity deal. And in these deals, if you mess up, if you lie in your testimony, the most you can get is a misdemeanor. That's up to a year in jail. So when you compare to 1 year in jail to capital murder charges for life in prison, you might want to make sure you do everything you can to get yourself a deal. Enrique Bocanegra's family deserves better. Now, the state wants to put blame on Oscar when there was a rush to judgment and everybody gets charged with capital murder, an incomplete and botched investigation, which Detective Morales told you about, and letting Jerry Ortiz, who's responsible for the death of 2 people, walk free. We talked about beyond a reasonable doubt. We talked about you would not lower the burden. You would hold the state to their burden. Even if there was a death involved, you would hold that burden to beyond a reasonable doubt. Remember, maybe something happened, probably, more likely than not, is not enough. You need to have evidence in front of you beyond a reasonable doubt before you can find anyone guilty of any offense. The presumption of innocence is listed in the jury charge. It tells you, essentially, you need evidence. And if the evidence isn't presented beyond a reasonable doubt, you must vote not guilty. Reasonable doubt is any doubt. You don't need 10 doubts, you just need 1 reasonable doubt. As jurors, you need to go in there, and if you guys should talk amongst each other, but ultimately, if your decision is like, I don't believe the state proved their case beyond a reasonable doubt, and other people do, it's all right for you to hold on and say, you know what? I'm sticking to my convictions. I'm not going to change my mind at this point. You've talked to me, I understand. I'm not going to change my mind. You don't have to change your mind. So the power of the jury is strong. You have the responsibility of holding the government to constitutional principles and its burden of proof. The state's going to talk to you after me and tell you many things, and I can't talk anymore at that point. All right, but they're going to tell you Oscar lied to Detective Morales. This kid, 19-year-old kid, was scared. He did lie a little bit to Detective Morales, no doubt. But he's going to also tell you that Oscar must have known this plan. It's common sense. That's just guessing, folks. It's not proof beyond a reasonable doubt. He's going to tell you to ignore the discrepancies in Jerry Ortiz's story. Ignore the discrepancies in Jeremy Martinez's story. Don't focus on the ballistics. Just focus on, look, we have Enrique Bocanegra's death here. Somebody has to be held responsible. No, in this courthouse, justice, fairness, and the law, you need to apply the facts of the case to the law. And when you do that, you're going to find that there is not evidence that proves beyond a reasonable doubt that Oscar Martinez is guilty. The state brought you a weak case, conflicting stories from people who have every reason to make themselves look good and for Oscar to look bad. We all know that Enrique Bocanegra would be alive if it wasn't for Jerry Ortiz and his .40 caliber gun. Oscar didn't murder anyone. Oscar's been waiting 2.5 years in the Bexar County Jail for this day. And here he is in this trial. While Jerry Ortiz, the killer of 2 people, has gone free because the DA's office didn't prosecute him. That's not justice, folks, and that's not fair. We know, and I told you in my opening statement, this was tragic. It was preventable, and it was mind-numbingly stupid on the part of all the parties involved. Oscar Martinez is guilty of lying. He's guilty of being stupid. He's guilty of running with the wrong crowd, the Mejia brothers. All right, but for count 3, He is not guilty of aggravated robbery. They didn't prove that he had a deadly weapon, because this is not a deadly weapon. And even if the prosecutor said, well, everybody else had weapons and he must have known about it. Really? Just because you're there and other people pull out guns, you're responsible for murder? No, folks, that's not how the law works. So count one and count two, he's definitely not guilty. We know he didn't pull a trigger. He didn't do any actions that made Christopher get out of that car. He didn't do any actions that made Jerry Ortiz shoot across the street and kill Enrique Bocanegra. It's tragic, it's sad, but we're dealing with Oscar Martinez today, and the evidence is just not there. It's okay in the end to tell the state, you didn't prove your case beyond a reasonable doubt. That's all right to do that. All right. In the end, Oscar Martinez is not guilty based on the evidence and the facts that have been presented to you. And really the lack of evidence brought to you shows that Oscar Martinez is not guilty of this charge. Once again, aggravated robbery. If this isn't a deadly weapon, they haven't proven aggravated robbery. Maybe there's some argument to be made that he's guilty of robbery because he's with the wrong crowd and he didn't stop it in time. You're not charged. You're not charged with robbery. You have 3 counts to consider: aggravated robbery and 2 for murder, 2 counts of murder. In this particular case, he is not, there's no evidence that this was a deadly weapon. All right. And if he's not guilty of aggravated robbery, he's not guilty of murder, and he's not guilty of murder. In fact, even if he was guilty of aggravated robbery, he still wouldn't be factually and with all the evidence guilty of 2 counts of murder either. Folks, Oscar's life is in your hands. We ask that you look at the evidence carefully, which I know you've been paying serious attention to every witness in this particular case. Find him not guilty, because that's what the evidence directs you to do. Thank you.
All right, state.
This case is about holding Oscar responsible for his actions. That's what the state's been trying to do from the beginning. We've said from the start that Oscar did not fire the gun that killed Christopher Mejia or Enrique Bocanegra. We've said that it's been Jerry. You're truthful about that. This trial has not been about who fired that gun. It's about whose actions played a role in what then led up into that gun being pulled and fired. Now, Oscar's been avoiding responsibility from the very start. The very first key piece of evidence that we have is that video, that surveillance store video that shows the robbery. Well, we know it's a robbery because Jerry's giving items up. He's taking off his shoes. He's going down to his socks. He's complying along every single step. Jerry doesn't pull out his gun to defend himself at that point, because at that point, it's not safe for him to do it. He gives over the shoes, and it's only whenever Christopher Mejia gets out of that car in furtherance of the robbery that's already happening that Jerry and Chris struggle over that gun, that they both end up shooting at each other, and that Jerry hits. He begins firing at the car full of people who have just pointed firearms at him. He's trying to hide to avoid getting shot, and he runs away at the first opportunity that he gets. That's what that video shows. The other angle, it shows Oscar getting out of the front of that vehicle. If you watch it enough, you'll see Oscar gets out because he's in all red. He stands out from everybody else. Oscar spent several minutes in that car before getting out, before checking on anybody. Then you do see Juan Mejia go and throw the guns. Now, you heard a little bit from Jeremy Martinez, who was there. He says that Oscar was the one who told them to take the guns. From the start, Jerry's cooperated without a deal in place for his own immunity. That deal that was signed did not give him any immunity from prosecution. It only allowed Jerry to come into the DA's office and tell his side of the story, and for that story to not be used against him at his trial. There was no exchange. Jerry's been cooperative from the start, and he even answered on the stand, "Well, you're just here to blame others." And Jerry said no. He was just there to say what was happening. This has never been Jerry's goal from the start to blame anyone. He's just been here to say what happened. Instead, if you look at Oscar's interview that he gives with Detective Morales, it's very shortly after everything's happened. Oscar can't keep anything straight. He can't even say really why they went to that corner store. He can never once say the same thing in regards to who said what. Go listen to it. Every single time he starts a story, he says something completely different. He purposely puts himself in the back of that car, away from the passenger seat. But he didn't know that this video existed. It clearly shows Jerry going to the passenger side window, talking to whoever's in there, handing the item straight to them. Oscar knew that that's what happened in reality, but he was probably banking on the fact that there would be no video to show it. So when he finds out there is a video, he has to change his story. And he keeps changing his story all throughout the interview. He never once is straightforward as to the sequence of events. At one point, he says that Christopher saw the gun and heroically tried to stop Jerry from shooting up that car. That's not supported in the video. Oscar doesn't mention the detail where you can clearly see Jerry handing over the shoes that were later recovered from that vehicle. Oscar then tries to come up with a story that, well, it wasn't me who was a part of this deal. It was Joshua Mejia and Christopher Mejia. A 14-year-old and a 17-year-old had an idea to rob someone. And Oscar, the oldest person in that car, had no idea what was going on. He eventually tells the detective, yes, I did know. They were talking about it. That's not what he immediately says. Because he knows that by giving the full truth, by saying what actually happened, he puts himself as directly responsible for everything that played out after. He even tells the detective, I know about the law parties. He tries to tell the detective that. And he later even says, you guys are just going to try and put me in this party. Now, again, Jerry came into the DA's office and he told his story. And he got up there on that stand and he told it again. Jerry took responsibility for everything that he did, for throwing away the gun, for being the one to shoot. He owned up to it. That took a lot of courage to get up here and freely admit that. And that deal, again, he could still technically be prosecuted. If something in the future comes up, that case is still technically open. He did not get any assurances there. Almost everything Jerry says is corroborated by the evidence, by the video. You see exactly what Jerry was talking about when he gave his statement. It syncs up with almost all the video that we have. And what does Jerry say? He says that it's Oscar Martinez sitting there with a gun, cradled right here to show me. It doesn't matter what type of hand he has. All he needs is his finger on the trigger and the gun pointed that way. And Jerry hits on that detail, and he's sure to say that I was terrified. When I looked in that car, everyone had a gun pointed at me. That's probably the most pressure that Jerry has ever faced in his entire life. And he gets only a few details wrong. There's an inch or two on a window. There's one less gun that he knew. But you get all those details in a snap second, few moments of getting to look at and survey the situation he finds himself in. Jerry didn't tell this to the initial detective because he was scared. He admitted that he wasn't helpful, that he didn't give any information to help work on. But again, him giving that statement, he came in and told his side of the story. Even Detective Morales said that after reading that would have changed my opinion if he had told me that from the start. If he had told me from the beginning what was happening. Because it's all supported by the video. Jerry acts at the last possible moment that he can. Christopher has a gun drawn dead on him. And at that point, Jerry knows it's either himself or Christopher. It's unfortunate that Jerry had to make that call. Jerry was not an accomplice. He didn't plan on getting robbed that day. He didn't plan on any of this happening. He just planned on finishing a drug deal. So he's not a co-actor. The
I
plan
object to this point, Your Honor. The jury charge clearly say Jerry Ortiz is a accomplice.
All right, ladies and gentlemen, the law comes from the court and you have the law in the jury charge. Does everyone understand? All right, State, you may continue.
And I want you to review that law. Was Jerry acting as an accomplice? That is something that you guys have the ability to believe or not believe. And now, there are interesting areas that Jerry's story and Jeremy's story come together. Jeremy Martinez does not like Jerry Ortiz. Jerry killed Jeremy's brother, Christopher. They have no reason to agree with one another. They have no reason to corroborate one another. Jeremy hates Jerry. And how it's corroborated is that both Jeremy and Jerry agree this was a robbery. Jerry was getting robbed. And even Oscar agrees Jerry was getting robbed. There's agreement from all parties on that. Jerry and Jeremy both say that Oscar pulled out some firearm. Oscar instead spent his entire interview pointing the finger at everyone else in that car for having a gun but himself. He wants the police to believe that a 13-year-old, a 14-year-old, a 15-year-old, and a 17-year-old had all these guns, and this 19-year-old had no idea that they had any of that he was never told, that he never had the ability to know what was going on. And that makes no sense. Jeremy even says, yes, it was Oscar that asked for the shoes. Jerry clearly in the video is giving up his shoes and talked about the fact that he just heard from that car, everyone acting together, give me this, give me that. Jerry was just trying to comply as best as he could. So, again, that's another area of agreement. It's the fact that they both agree, Jerry and Jeremy agree, that it was Oscar who started the talking. Oscar who was the one communicating with Jerry. Jerry just says that after a few seconds, it just becomes overwhelming. Everyone started talking at him. Everyone started yelling from that car. But again, they were all acting together to commit the robbery. Now, Oscar had no idea that Chris would do that. Well, does that make any sense? Because the defense asked you about Harley, and would it make sense if Jerry had not asked Harley to be a lookout? Well, that cuts both ways. Isn't it strange that Oscar, the 19-year-old, again, had no idea that they would be participating in a robbery and that he would not have put a gun in someone else's hand? That doesn't make sense. Again, Oscar knew exactly what was about to happen. He played a direct role in that robbery. You have that from Jerry. Oscar has spent this entire time trying to avoid the responsibility. He's been trying to keep himself away from the front passenger seat, which both Jerry and Jeremy independently say he was sitting. He tries to avoid playing any role for what Christopher, Josh, Jeremy, or Juan did, despite being the only adult in that car, the oldest person. He's riding shotgun. He's the one directly talking to Jerry whenever this is all happening. So if he had an idea that this was a robbery, like he said, where they spoke right before, then he knew exactly what was happening in that video when Jerry was giving up his shoes. He knew exactly that the goal was to get everything he had, for Jerry to give him what he had. Give me what you got. And now it's at this point that Oscar then tries to blame everyone else in that car but himself. To put a gun in everyone else's hands but his own. To say that he had no idea any of this was coming. When in reality, you have from Jerry, the victim in that case. He's directly telling you what happened. Now, the defense has been bringing up that mere presence is not enough, and it's not. Just being there is not enough. But you have one source directly putting a weapon in Oscar's hand, starting the entire robbery. Another source says he has a weapon, but it's different just slightly as to what exactly he said. And then there's Oscar saying, I had no idea any of this was happening. I had no idea what they were going to do. And I played no role. Even though he's the one that Jerry is directly talking to in that front seat passenger at that window. Oscar knew exactly what he was doing. And he knew from the start in his interview that he had to blame anyone else but himself. Why he tries to blame Jerry at first, hoping that that will cover for him and his friends. He then blames Christopher and Joshua. Christopher's dead. He can't defend himself. And Joshua's been shot. He tries to blame all the minors in that car. Even though, again, as the oldest, he has the ability to say no. He has the ability to ask where we're going. Oscar wants you to believe that none of that ever happened, that he never once thought about asking where we're going, what we're doing, none of that. Jeremy brings up Oscar's the one that directed them to hide the guns. Now, I know there are issues with Jeremy's testimony. That does match up with the video that Oscar was in that van, in that Suburban, far longer than the other people were. That corroborates what Jeremy's saying. Jeremy was upfront with his brother's involvement. The only time he didn't want to give more was because he wanted to blame Oscar. That's what Jeremy came in here to do. And Oscar earlier tried to blame the Mejias. There's only been one person who's been consistent this entire time as to the fact that it's everyone in that car's responsibility for what happened. Again, the state has proven its case beyond a reasonable doubt. You have all the information. You have Oscar's own statement that does not match up with the video. You have that video directly corroborating what Jerry Ortiz said. You have video corroborating what other witnesses have said as to what happened after that after the shooting and what happened after everything the police started to get there. You have plenty more than just Jerry saying it. But again, Jerry owned up and did the right thing. He came in and was trying to tell the truth. Oscar did not fire that gun, but he directly participated in this murder, in its buildup, in the fact that it was going to happen, that something was going to happen. The state is asking that you find Oscar guilty on both counts of murder and on the count of aggravated robbery. Thank you.
All right, ladies and gentlemen, you've heard closing arguments from both parties. The deputy is going to take you to the back to begin selecting your foreperson and begin deliberations. Everyone, please rise for the jurors. All right, everyone, please be seated. State, because defense went longer in their closing argument, I allowed it because this is an important case, but I gave you all extra time as well.
Yes, ma'am.
All right. If you all want to make sure that the exhibits are the way they're supposed to be so that the jury will have what they need, of course, the guns are not going to go back unless it's requested.
Good job. I decided I was like, I'm running out of stuff. Oh yeah, I think I would look it up. He did, yeah. I saw that. No.
Oh, yeah.
Sounds like
30 years later.
Where? How's it, everybody? When you do.
I'm over it.
We'll put it on the-
Yeah, through the field of the highest suicide rate. Documented.
I don't know. So my guy got arrested last time he was in court because he had that misdemeanor that had been unsealed. And then it took 5 days to get him out. He did bond set the same day.
Well, the money's there, there's that.
Yeah, but you-
Allegedly.
Let me get my list. Oh.
Oh.
Did I show up?
Excuse me.
Yeah, yeah, yeah. Supposed to go,
That demonstrative is gonna bring it.
Nice view.
Yeah. Evidence that it-
Yes, ma'am. Yeah, GSR report.
I have one.
You guys, picture of David.
I think it's.
It's a board guy.
But I think she picked up what. Get it now.
No, we were talking about it.
I walked through and it didn't go off.
I didn't take it off one time, and she was my advocate.
I know.
Getting them out to like give however. Oh, yeah, now we need.
No, you started this. You were in charge.
So everybody who's here in the middle of the web, don't have to have y'all step back a little bit while we get the evidence sorted out.
What?
But please feel free to confer with the state, but just not in this area.
That does.
What should you know? I have no clue.
Yeah. And still there's.
Yeah, you probably did, but I'm saying, like.
Yeah.
Mhm.
Okay, you know what? Pick it out. It wasn't.
If you want. Go back, so you have a bunch of spread out. That's right. That's okay. And you have one version back. Yeah.
Do that.
This is. So I have to. Sorry. That way you obviously look at it and share it. Once you teach my house, everything I put. Okay.
I got you. This.
A lot of trouble. And you're in the middle of it.
No.
This is Jason and Garahan, and my password is expired and it won't let me log on. I'm in the court. Does that matter? Or do I have to be? Okay. What's expired over the weekend? Yes, please.
Like in terms of. Let's do a current update.
Just do password one or no?
So it has, yeah, because, well, what happened is.
I mean, I'll change it.
Right, she picked up the case for cause, right, she was in custody, had to be evaluated, then she picked up the assault in the jail, which then she picked her off the list, and now we got her, but it's still in.
Okay.
I don't think, that's the answer. Checking on.
Can I give you one? That's maybe gonna work. Like a new one, right? Yeah, can I do a capital P? Then lowercase O P O. There we go.
Oh,
And 0. And then you know, when you do shift 9, which would be a parentheses. And then Q, lowercase q W E.
Yeah, you're able to help NTR. In what we would call.
Yeah. Capital C O, and then lowercase O P O. What's that? Yeah, like Popo. And then 0. And then shift 9 key, which is a left parentheses.
Yeah, appreciate it.
And then lowercase q, lowercase w, lowercase
I
e.
don't know if anything's open.
Trying to.
But it looks like
Try
a
not.
few misdemeanors and counting
Well, I mean-
12. I just don't know if they are
Don't spin your wheels.
open or closed.
Right, yeah. With the other goal of. Yeah. Good balance.
Yeah.
Yes, ma'am.
Hello? Oh, that's so funny. I'll tell. Bye.
What's up?
Yeah.
But on the newspaper, it was put on.
Okay.
Oh.
All right, we're going to go back on the record in 2022 CR 4932B, State of Texas versus Oscar Martinez. Could I have parties announced? All right, and we're on the record because there needs to be an item that needs to be relabeled. Is that correct? And defense, do you have any objection to your client not being here for the relabeling of the item? All right, so Officer Arriaga's report will be changed from defense exhibit number 3 to defense exhibit number 9. Is that correct? Correct. All right, and it's the court's understanding that that defense exhibit number 9 was never admitted into evidence. That's correct?
Yes, ma'am.
That is correct.
All right, thank you. Wow, the yellow roses, and I bet you they're the yellow roses of Texas. Good morning. All right, so everyone, rules still apply. If we're still gonna recess at 12, but if you all will just place your file here and I'll call you all in the order of appearance. Yes. Oh, what? Let them know, they'll be able to pull a B page or something for me, because I need something to write on if you're requesting something.
I can't do a B page. I can try to see what I can print though.
All right, thank you. Thank you. Oh, then if it's on it, is it indicted?
No.
Oh, okay, never mind. Different one, Judge.
Okay.
Well, we might have a problem with that one.
All right, who's here on Israel Cortez?
Hey, Judge.
Hi,
Good morning.
good morning. He's in custody?
He is now.
Okay.
All I'm asking is that we call him back tomorrow morning. I know you have a ton of cases today.
Mhm.
We can take care of everything tomorrow morning.
All right,
Have
so,
a meeting right after this.
okay. Ms. Ferguson, on this case, Cortez, can we recall him for tomorrow? It's a plea deadline date today. All right, so we'll bring him back tomorrow.
Thank you, Judge.
All right, thank you. State, Israel Cortez is going to be recalled tomorrow. Yes, and it's a plea deadline date.
You're ready to go?
Well, he's not out yet. I just need a confirmation, but. No, I just can't come back up.
Mariano Rendon.
Hey, Your Honor, how are you
Hello.
doing this morning?
Oh, I'm doing great. How are you doing?
Hey, Judge. Judge, he's got 2 cases. He's got one set today and he's got one set on June 20th, which is just in a couple days. With all the e-file stuff, I had some difficulty filing a notice of appearance on this case.
Mhm.
I took over for Mr. Molina. So I'm just asking if they can just recall this case to the 20th. And that way I will be able to, on the 20th, I'll be able to get all that stuff completed and I'll be able to file the discovery acknowledgement.
State on Mariano Rendon. This is scheduled for today, but he has another case that's set on the 20th. This is going to be the attorney on that. So 20th, you'll still need to be prepared to tender an offer.
Yes, Your Honor.
All right. Once you sign the reset form, you're excused.
Thank you.
Ms. Ferguson, if you can put this on the 20th.
Yes, ma'am.
And counsel, make sure your client is on time next time.
Yes.
Matthew Rendon.
He's here, Judge.
Oh, is he?
He was the one we just called.
Oh,
Oh,
is he?
Matthew's a different
Yes,
one.
Matthew. Who's here for Matthew Rendon? All right. Anthony Cochran. Come forward.
Good morning, Judge.
Good morning.
I do like the yellow.
Oh, you know, my mom had a yellow rose of Texas and it grew so high, it grew to the rooftop. Yes, and then my mom had someone moved it
and it didn't make it.
Didn't make it.
We had one at my parents' old house. And we didn't try to move.
Yeah, but the roses were
Uh-huh.
huge.
You just get, when it gets that big, they get.
Yes. Now they say with roses, they've started, I don't know what the other term for it other than breeding. Well, they've been cross
Mhm.
referencing it. So they're trying to take the scent out because it attracts the bees and everything. I guess people want that. But if you look at roses now and sniff some of them, usually it's only the antique roses. They'll still have
Mhm.
their strong fragrance, but a majority of them don't.
It's a
And I'm
shame.
just, yeah, it is. It's like, guess what? Let the bees find where they need to go.
You can eat bees too.
Yes.
Normal bees is a bad thing.
Yeah.
Judge, I represent Mr. Cochran on two cases. They're both active. I've looked, there's over 40 videos on one and over 35 on the other. I'm through looking at about half of it right now, so I don't really want to sign a discovery acknowledgement just yet because I'm not sure if there's other stuff that I need to request.
Or
from
who
the
you
state.
conferring with?
I've conferred with Jason this morning. I can't advise my client to take or not take a deal
No,
yet.
no, no.
so-
I'm just trying to
Yeah.
figure out if an offer was tendered.
No, I didn't ask for one, to be
Okay.
fair, but we did talk and I explained to him, we've been going through, watching the videos at the office, so.
All right, so I'm gonna give you all a 30-day reset. This
That's
is gonna be the
perfect.
last time.
Okay,
And then at the 30-day mark, the state will need to tender an offer. Then what will end up happening is your next date after that will be a plea deadline date.
Okay. I'll explain all that to him.
All right,
Thank you
thank
so
you.
much.
Thank you.
Judge.
What date, Ms. Ferguson? 30 days? Yes.
Okay,
All right, July 16th.
It's on a Tuesday, July 16th.
All right, July 16th.
okay, and that day I'll sign the acknowledgement. And
All right.
get rid
You're welcome. Once you sign the reset form, you're excused.
of it.
Oh, does she? Mhm.
She puts on my downloaded on my delivery.
Oh,
She labels them.
that is awesome.
She wants to go to law school.
Oh my gosh, I'm so excited. See, it will be it will be a mother-daughter duo.
Have mercy. Well, my brother starts in August, so.
Oh, wow.
it all-
So he's finally gonna do it. That is awesome. I always thought he should.
He's doing the part-time, so he'll keep working for us, but be able to go. We're excited.
All right, who's here on Joseph Ramirez?
I was here last week on Mr. Ramirez,
Yes.
and you asked that we file a motion. I conferred with the state. They're okay with $20,000.
Okay, is your client here?
No, I didn't.
So,
He's locked up.
so what we can do is we can recall it for tomorrow, but they have to be present. The law has changed, so there are questions that I need to ask of him related to conditions and everything. So
Okay.
I can have them place him on the docket for tomorrow.
Yeah, let me check with the coordinator and do that.
All right, Norma, if you can have them place him on the docket for tomorrow. If it's doable, Deputy Laura. Are the parties here on Matthew Rendon?
Thank you, Judge.
You're welcome. Have a good one. So Deputy Laura, it brightens the day. And the card brightens the day, you know, with the sunflower.
I was telling you that. Yellow roses, my yellow shoes.
Oh, yes.
Because the light you love.
Oh, I love yellow roses. Well, I love roses, period. I love flowers.
You know, I had seen, and I didn't know that they existed, was a lavender rose.
Yes. Oh, well, not only that, my mom used to have purple roses. Yes, so it's something that they do with, I don't know what it's the botanist term or whatever it is. But yes, so my mom had purple roses. There was a movie actually that involved a purple rose. So then my mom was, you gotta get a purple rose. And then the Moroccan roses, they're sort of brownish with the tinge.
I didn't realize that they came in so many different flavors.
Purple Rose of Cairo.
No, but I did enjoy the Purple Rose of Cairo, but there is another movie, because when I was growing up, they would have Sinbad. So, the claymation, yeah, Sinbad the Sailor. So they would have all of those programs. So this one involving the Purple Rose. I'm gonna remember the title of that movie. I'll call you at 1 a.m. when I remember it. But they had to find this purple rose.
So it's based on fact.
Yes,
Thanks.
sure, you're welcome. Deputy Laura, would you all want to go ahead and place the order? Do we want them?
You're gonna be there all day.
Hmm,
You're gonna be in there all day.
yeah, that's why we should go ahead and order.
You as well.
Let's do that, but make sure I get. Maybe do 2 of those. Yes, where is he?
Right here.
Come forward.
Dressed all nice, coming up
I
here.
love that you on this side.
Yes, ma'am. Slide to the left.
Hi, counsel, have you received all the discovery?
Your Honor, I think I have. I wanted to have, when we talked, this is officially our first setting.
And state, were you able to tender an offer yet or no?
Not today, Your Honor. There's been a discussion about an offer. It's just that, we want to try to contact the victim in this case.
All right, Ms. Ferguson, can you give me a 30-day reset on Anthony Villarreal? And state at the time you need to prepare to tender an offer.
Yes, Your Honor.
July 16th.
All right, July 16th.
Sounds good, Judge.
All right, why don't you sign the reset form, the excuse?
Thank you, Judge.
Everyone, we're taking our break at noon.
I'll take it to you.
We're gonna have to finally give in and go to the benefit. We're gonna have to finally give in and go to the benefit. And then we don't have it again, but you know, because of the-
Hey, this Villarreal on?
I held it off.
I didn't see him.
Gotta go.
Okay.
I hate that.
Oh, he wasn't. That's true.
There's like such a correlation.
All right, is the attorney here on Matthew Rendon?
You want me to put it at same?
Not yet.
All right, just give me 2 minutes. I need to call my mom very quickly.
Can I have a moment?
Yes.
Just a short. As you know, I'm filling in for Ms. Carter's office. We had an agreement on setting a bond for Mr. Tez.
All right, you just need to ask him to pull the file.
Okay.
What's the name?
Joshua Tez.
Renee Camarillo.
Had a special setting just because the judge wanted this.
Hello. So, where are we on discovery?
Judge, this is the first setting. We do have a lot. I'm trying to make sure I have all of the body cam footage for every single officer. It's a lot to go through, so I'm still working on it. I have a lot, so I may have it all, but at this point, I'm not confident and able to tell you that I'm not missing things.
All right.
I did file a motion to suppress on this case. I'd like to have a hearing before trial if possible.
Motion to suppress what?
Statements.
All right. Of your client?
Yes, Judge.
Okay. All right, Ms. Ferguson. On this case, recall it for discovery. Mr. Camarillo, we're going to recall this for discovery in 60 days to give your attorney to make sure, time to make sure she has everything. And state you believe you've uploaded everything?
I just checked the case out on Thursday or Friday of last week. I believe most of the videos are there, but again, that's not to say that maybe one's missing or something. And if it comes to light, we can definitely obtain it.
All right, if you're, Norma, a 60-day reset.
60 days, so I'm on a Friday, Judge, so I'm gonna put it for August 19th. It'll be a Monday.
All right. We'll be back on August 19th.
August 19th.
Do you have any questions?
No.
All right, so we'll bring you back on August 19th. What's going to happen on August 19th is just a date to make sure that your attorney has everything about your case. You understand?
Yeah.
All right, thank you.
Thank you, Judge.
You're welcome.
Go have a seat. Okay.
Oh, they were. I guess I could be wrong, but that's not.
Joshua, tell us.
Yes, Your Honor.
All right.
Your Honor, would the court be okay with my law clerk to appear at the bench?
Sure. But y'all are on this side.
Yes.
And where's your client? Come forward.
Introduce yourself to the judge.
Your Honor, I'm Miguel Esparza. I'm
Hi.
an officer with Cutter and Associates,
So are you in law school or going to, where are you attending law school?
St. Mary's.
Oh, wow. What year?
I'm a 2L now.
2L? Oh, well, you're practically done.
Yeah, almost.
Well, please, whenever you want to come down, you're more than welcome to come down to the court.
Thank you.
You're welcome. All right. Who is the prosecutor on, how do you pronounce your last name?
It's Thayers. It's like TH, it's pronounced THE.
Tayez. All right. So if y'all will move towards this way, because counsel, you're on this side and your client is in the center.
How you
The
doing?
double
today,
L's,
boy?
oh, I'm doing great. The double L's always get me.
Yeah, the E has that little apostrophe on top of it, so, yeah.
Well, we're gonna blame it on that because in the documents, they don't have apostrophe over the E.
Yeah.
So Tayez. Do you all have the motion?
We have the motion as well as the agreed order, Your Honor.
All right, so if you could give me the motion. Thank you. All right, court is calling 2020 CR 2266B, State of Texas versus Joshua Tayez. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Your Honor, Anthony Bancroft standing in for Miss Lee Cutter,
All right, and then you have with you also.
and I have my.
You want to announce?
Miguel Esparza.
All right, thank you. And are you Mr. Tayez?
I am.
All right, Mr. Tez, you have an attorney who's standing in for Attorney Cutter. Do you have any objection to your to this attorney standing in for Ms. Cutter for this hearing?
No, ma'am.
All right, so we're here to set a bond. He's on deferred adjudication, so he's entitled to a bond. It's my understanding that the state and defense have reached an agreement of $10,000. Is that correct?
That is correct, Your Honor.
That's correct, Your Honor.
All right, for the record, the court is aware of the defendant's history because he is on deferred adjudication out of this court. And the court has done the appropriate research that's needed in order to set a bond. The court will find that the bond in the amount of $10,000 that has been agreed upon by the state and the defense is an appropriate bond. Now let's talk about conditions. based upon your history, the court is going to order that you do weekly UAs with probation until your case is heard. Do you understand?
Yes, ma'am.
And we're going to set this, normally we need a hearing, just set it for a contested hearing. I don't know if it's going to be contested or not, but we'll put it on a contested date.
Yes, ma'am.
And we're off the record.
Thank you, Your Honor.
All right, and I'm sorry, state you're excused.
Your Honor, may I be excused?
Not yet.
July 11th.
All right, we're coming back on July 11th at 9 a.m. and that will be your hearing. I am telling you this. I always keep an open mind on everything, but between now and then, if there's some issues in the motion to revoke that need to be addressed with you doing certain things, it would probably be in your best interest to do those things. And when I put on here that you're to do weekly UAs from now until then, you had better do weekly UAs from now until then. You
Is
understand?
there a designated day or do I just go
Oh,
on?
probation is going to let you know. So they're going to keep you out here till you talk to probation. And Ms. Ferguson, if you can give them a reset
Yes,
form.
I'm doing, I just need the file, Judge.
All right, here you are. All right, that will be it.
All right, then, Ms. Boyd, you have a good day.
All right, thank you, you
Your
too.
Honor, thank you for your time and your patience.
You're welcome. Have a good one. Hey, and good luck.
Thank you.
It's going to go quickly.
Yeah.
Enjoy it while you can, because afterwards, once you start signing your names to things and it's only your name and you're not practicing under somebody, that's when your
Yeah.
heart beats.
Thank you.
You're welcome. Have a good one. All right, anyone here for Matthew Rendon? All right.
May I approach?
Yes.
It's a question. On tomorrow's docket, I've got a client that we were going to plead tomorrow. He checks himself into rehab about 3 weeks ago, and he finishes on the 30th. I've got documentation from the counselor. If I file a continuance with the court to consider allowing him, it's one of those things, if he leaves the program, he's got to start it all over again.
Okay. All right. You'll need to have them pull the file and I'll consider it.
You'll file a continuance today and do it tomorrow? Or do you want me to do it?
Whenever if you want to do it tomorrow, you can do it tomorrow. If you want to do it today.
If we can.
Sure.
I'll do that. Thank you.
All right. Who's here on Satara Portillo?
Covering that for Joanne Williams.
All right. Portillo?
Judge.
Hello. All right, everyone in the gallery, if you're not talking to your attorney, you need to be seated because that puts the deputies on alert. Have a seat. All right, court is calling 2023 CR 2172, State of Texas versus Satara Portillo. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanne De Hoyos. Joseph Statesman standing in. Ms. Portillo, will you give this court permission for me to do this in place of Ms. De Hoyos?
Yes. All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satari B. Portillo who was placed on deferred adjudication in 2023 CR 2172 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35 on or about the 25th day of March 2024 in Bexar County, Texas. Defendant Satara B. Portillo who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 35?
Yes.
Court will find violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor. It's to alter demand for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all If you want to reconsider things, you can, but I'm not following that agreement.
We could step away for a moment.
Kevin Curiel? Yes.
Yes.
Hello. So the last time we were here, my understanding, all discovery was received. State, were you able to tender an offer in this case?
We were we have, Your Honor. I'm also getting, Mr. Edelman up to speed on this one.
Okay.
But we have made an offer.
And Judge, if I misspoke last time, I apologize. What we were waiting on last time was criminal histories of the witnesses. And we still have one criminal history outstanding. And so I've asked for
Who
that.
is that?
That's of Moses Leal.
Yes, Your Honor. We've sent an email to our investigator to pull that TCIC and CIC, Your Honor.
Okay. All right, Ms. Ferguson, if you can reset this for 30 days, that's your plea deadline date.
Thank you, Judge.
You're welcome.
July 16th.
All right, so we'll be back on July 16th. On July 16th, you'll need to let the court know whether or not you're accepting the state's offer. State, you should be able to have the criminal history of the witness they're seeking well before then.
Yes, ma'am.
All right. So they'll have that before the end of June.
Thank you, Judge.
All right, thank you.
May we be excused once we get the
Once you
reset?
sign the reset form, you are excused.
Thank you, Judge.
Thank you. All right, thanks.
Orlando.
Walter Weller.
Morning, Judge. That's a client that I just discussed with you.
All right. So he's being released June 30th?
That's what I was told yesterday.
Okay.
And he'll be a plea. We had
All right.
scheduled this for him.
Norma,
Yes, ma'am.
on this one, they say this is going to be a plea. However, he is in rehab.
Okay.
And they say he'll be released on June 30th. So can we recall this for maybe the 1st?
Yes.
All right, so we're going to come back on July 1st. All right, thank you.
Thank you, Judge. You need to sign it.
Jamaica back from her. Jason, did you start tomorrow or Daniel?
Here you go.
Judge, can I ask you a quick question?
Sure.
But on this case, if I want to get a second chair appointed, do I have to file a motion or can I just ask you right now for one?
You can file a motion, but the one that it's going to be most likely will be the person off the wheel who's up.
Right.
Yeah.
Okay, so I can't say I want Scott McCrum to sit with me.
No,
No.
you'll have to talk to manage assigned counsel.
Got it. Okay. Okay, thank you.
Sure. And Mr. McCrum, I'm fine with saying that a second chair be appointed, but they've changed the rules, so you all will have to talk to manage assigned counsel and see if manage assigned counsel will.
Specifically allow me.
Yes.
Okay, thank you.
You're welcome. You're welcome. Are y'all ready on Fatia? Okay.
Thank you. Have a good day.
Oh, Norman, were you able to order?
Yes, ma'am.
All right, so what we'll do is we'll take our recess once lunch arrives.
Okay.
Excuse me. Excuse me. Oh, not you. Here. Oh, Robert Maurer, you made it back.
in a timely fashion.
In a timely fashion. How was out-of-county cases?
Luckily about 10 o'clock, the judge called her coordinator and said she could go ahead and reset cases because she wasn't gonna make it.
Okay.
Usually it's about 10:30,
Okay.
and I would have come here first, but they don't answer the phone up there.
Ah,
And you know how small towns get, y'all cranky. Oh, you would San Antonio first. Like, at least the judges take the bench on time.
Bashan, on Mr. Joshua Tejas. He is in custody. And here's the case number. Could you give that to her, please? Jennifer, could you give that to Bashan? So bond was granted. And I'm ordering that he do weekly UAs with probation until his case is set. And we already have a date for contested. Ah. All right, so Mr. Tez, you're gonna have to, on your own, probation will probably be able to tell you somebody who does outside testing, but you're gonna have to do outside testing with someone else. And then, but make sure that you stay in contact with your officer, you understand? They are not gonna do the drug testing. Probation is informing they can't do it because there's a pending motion to revoke. So they'll be able to give you some ideas of people who do it for inexpensively. So she'll be able to give you some ideas. Okay, you're welcome. Oh, no problem. And Mr. Tejas, if there's an issue or you don't know where to go, come to court and I'll find some place for you. All right, thanks.
I think it's great.
And Norma, what date did you recall Tejas for?
July 11th.
Right. He's set for July 11th, Bashan.
Yeah.
Oh, thank you. All right, who is here on Vince Ibarra? The attorney for Vince Ibarra. Who is that attorney?
Orlando? We've already taken care of this.
Vince Ibarra. All right, Vince Ibarra, come down.
So much time, Mr. Barr.
That's what I'm doing that.
Court is calling 2024 CR 3778, State of Texas versus Vince Ventura Ibarra. Can I have parties announced for the record for the state?
Daniel, support for the state of Texas.
Defense?
Orlando Castañon.
Are you Mr. Ibarra? Counsel, have you received all the discovery? Did you review it with your client?
You have, Judge.
Court will find that the state is in compliance with discovery. Mr. Ibarra, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Judge, we're gonna waive count one and go on count two, and we're also waiving the repeat offender enhancement allegation.
Any objection?
No, Judge.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand and count to your charge of possession of a controlled substance penalty group 1 gram to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Ibarra, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
Ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sure did. Yes, ma'am.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State Office Exhibit 1 and all attachments.
No objection, Judge.
All right, did you review the document? State, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything that you wish to say on behalf of your client?
Just judge that, believe this is a fair agreement. He understands he has an addiction and that he is looking to address that. He does have a parole case that we asked that this be run concurrent with. That cause number is 2022 CR 2107. He's currently out on parole and awaiting a revocation hearing on that.
All right. The court is going to find you guilty. Court will sentence you to 4 years in the prison. Give you credit for any time served. There's to be no contact with Margaret Marie Gomez. This is run concurrent with 2022 CR 2107. I'll request the therapeutic community. The therapeutic community does not increase the length of time you're in custody. It's just a program that potentially could help you if you're accepted into it to kick your drug addiction. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
35 years old.
All right, so you're getting close to where you're going to have more of your life behind you in front of you. You're going to have to make some decisions on what you want to do with the rest of your life. If what you want to do with the rest of your life is spend the rest of your life incarcerated, Texas will definitely provide a prison for you. You understand? All right, good luck to you.
Thank you, Judge.
You're welcome. Isaac Cabello.
Judge, that's my case. It's an agreed travel permit. I talked to Jason Garrett and he agreed to it.
Okay.
Yeah. I don't know what policy. Randoms.
All right.
Thank you, Judge.
You're welcome.
Matthew Rendon, Judge?
Yes.
Judge,
Matthew Rendon.
He's not here, Judge. I had it on my calendar for June 20th. I didn't have him I just got a call that
I know it's scheduled for June 18th.
his co-defendant, June 18th.
Okay. Yeah. Oh, it is June 20th.
Okay,
That's why I have it on my, and here it's written for June 20th.
right.
Okay.
So he's not a no-show for today.
No.
Okay, we're good.
All right, thank you. Norma Rendon. It's June 20th.
Okay, let me. Okay, give me 1 second.
Oh, don't worry.
I'm trying to. Angela, right?
Yeah, Angela Pettis. But I checked Friday, she still has active warrants and call for other cases too. I think the judge here also after the one.
Not on the bill for 3.
Oh, okay, well, she did on the other days, I guess. I'll show later on. No, we're just gonna have you issue a warrant, Judge. That's it.
Here you go. That's okay.
That's not as.
The busy one.
All right. Who's here on Angela Pettis?
I am Judge Rainville for the defense.
All right. Where is she?
I don't know, Judge. I've had no contact with her. She hasn't shown up for other cases and warrants were issued for those, both in misdemeanor court and some companion felony cases she's got with this court.
So there should be a warrant. Is there not a warrant on this case?
No, we checked,
All
Judge.
right. All right. We're going to go on the record. Court is calling 2024 CR 0431, State of Texas versus Angela Pettis. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
For the defense?
Raymond Bell for the defense, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 11:59 a.m. The defendant has not made an appearance. From the docket sheet, it shows that a second violation report was issued and there was a judge's warrant for a remand without bond. And the defendant was a no-show on May 30th at that time. Have you had any contact?
No, ma'am. We've sent correspondence. We don't have good contact information for her in terms of phone or email.
State's requesting I guess, a judge's warrant, Your Honor.
All right, I'm going to issue a judge's warrant. Your client will be remanded without bond.
Yes, ma'am.
If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
Thank you.
May I be excused, Your Honor?
Yes,
Good to see you.
you too. All right. All right. All right.
I don't think they have the equipment.
We'll figure something out. Yes,
I'm ready on Portillo.
all right. Portillo? We're gonna go back on the record in 2023 CR 2172, State of Texas versus Satara Portillo. Can I have parties announced for the record?
Daniel Escobar for the state.
Joseph Stateson, continuing to fill in for Mr. Hoyos.
All right. The defendant had entered a plea of true to violation of condition number 35. Do you wish to continue with your plea of true in violation of condition number 35?
Yes.
All right, the court will find violation of condition number 35 true. Is there a proposed agreement?
Your Honor, if I may,
Yes.
I discussed this with the COO, Ms. Abrams, and ADA Daniel. My client is asking to be continued. We had a recommendation that was a three-way agreement. I understand the court didn't want to follow that. I had proposed something to Daniel. I'm hoping that you would consider this. But just some background a little bit first. Her prior MTR was disposed of February 27th, 2024. But she was booked February 3rd, 2024. So from February 3rd till today, according to the clerk, it's 137 days. So she's had the equivalent of a, not court ordered, but equivalent of a 4-month jail sanction. She will admit, well, she did admit that she refused to sign conditions for inpatient. She's willing to do not just ISF, she's willing to do SAT-F. She's willing to redo all her classes. She's been in jail for quite a long time. That's her own mistake. She admits that she didn't want to sign it. Maybe she was reluctant to, but she thought that she was supposed to get out, have court, and come back and do things. And she never left the jail. And out of frustration, she didn't sign the conditions.
No, I don't think she's a good candidate for probation. She was supposed to sign the conditions, the TAP recommended inpatient treatment, and she didn't do it. So I don't think she should be continuing on probation. She was given opportunity, and counsel, as you just stated, this is not her first motion to revoke. Her previous motion to revoke was on February 27th, as you stated, and there was a violation of condition number 1. And I ordered that there be a TAP evaluation in custody to follow those recommendations. And she decided that she didn't want to follow those recommendations. I don't see how there's anything that I can do anything for her. People don't get it. You're not supposed to, when the court orders you to do something, for example, to help you by following the recommendations of TAP. TAP recommended inpatient treatment. And I know sometimes people get to talking to people at the Bexar County Jail. And when I say people at the Bexar County Jail, I mean other inmates. And they give people advice, and people want to follow the advice of an inmate, not realizing that, guess what? That person is in custody. But I made an order, and we can't do this thing where I order somebody to follow the TAP recommendations, and the TAP says inpatient, and then somebody says, I'm not signing to go to inpatient. And then what ends up happening when reality hits that your range of punishment is 5 to 99 years or life, then people come before the court and they want to say, oh, you know what? I changed my mind. Now I will do inpatient treatment. So that's where we are.
And
I don't
Your
think
Honor,
she's a good candidate.
She's also willing to take a felony conviction, change it from deferred to straight probation. She's willing to do the harsher inpatient treatment program with 0 tolerance. It was a poor decision for her to not sign that. 4 months she's been in here. She's willing to sign this, willing to do this, and even add to these conditions.
I just don't think she's a good candidate. If somebody wants to argue to me why she would be a good candidate for probation, when this is her second motion to revoke, and I ordered her to follow the recommendations of the TAP evaluation, and she didn't want to follow them. But now she does because, I don't know, I guess she thought a motion to revoke would not be filed against her.
Yeah, I didn't know that that's what would result.
Oh,
I
so
thought
these are called consequences.
Well, Your Honor, also the charge itself, people who are affected with these substances may not make the best decisions in life. To prevent her from reoffending in the future, relapsing. And she's willing to do even more intensive inpatients.
But she's charged with possession with intent to deliver, and I understand that sometimes when people have possession with intent to deliver cases, sometimes they're selling because they're also using. But the amount of methamphetamine she had was 27.980 grams. I don't think probation is appropriate for her. I'm not going to continue on probation. I'm going to revoke her and find her guilty. Does anybody wish to speak to punish them?
Defense would ask for the minimum time, Your Honor, with credit for time served.
All right, I'll sentence her to 5 years in the prison. Give her credit for any time served. And I'll ask for the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Yes. But you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand? Yes. All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. All right, good luck to you. Thank you. All right, can I see the attorneys on Oscar Martinez in the hall, please? Yes, ma'am. And everyone, please continue to confer in the hall.
Yes.
That's where we.
Matthew, Waverly Whitlock. Hello, good morning.
How you doing?
All right. So what is happening with this case?
Your Honor, we got an offer.
Everyone, please whisper.
Your Honor, we received our first offer today. We're just asking for a short reset for next week so we can consider what we want to do.
All right, is next week enough time?
I think so.
All right, Ms. Ferguson, can I have a reset date on this for next week? For our plea deadline date?
Yeah.
I can do Tuesday, the 25th.
All right, so we'll come back on June 25th.
Sounds good. Thank you, Your Honor.
All right, thank you.
Have a good day.
You too.
I see, ma'am.
Oops, sorry. Gilbert DeLeon.
Morning, Judge.
Good morning.
No, you got it right.
Yes, yeah.
Hello.
Hello.
All right, Mr. DeLeon.
Yes, ma'am.
The state has filed a motion to dismiss in your case. So whatever brought you here, remember, this could have gone a different route, you understand? So if there are changes you need to make in your life, then make sure you make those changes, all right?
Yes, ma'am.
All right, thank you for dressing appropriately for court.
Thank you.
You will be excused.
Thank you very much.
You're welcome.
Appreciate it.
All right. Wesley Mulkey. Where's your client?
He was right behind me.
Judge, I keep hitting the flowers.
I gave it 2 year olds.
All right. Are you all proceeding on the motion to revoke?
We are, Judge.
I'll wait to the blue arrow.
All right, the court is calling 2016 CR 0791 State of Texas versus Wesley Darnell Mulkey. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
David Andre Woodard for Mr. Mulkey.
Are you Mr. Mulkey?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Wesley Darnell Mulkey who was placed on community supervision in 2016 CR 0791 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on October 17th, 2016 for a term of 5 years and extended for a total of 3 years?
Yes, ma'am.
State?
Yes, Your Honor. Violated condition number 1 on or about the 17th day of March 2024. In Bear County, Texas, the defendant Wesley Darnell Mulkey committed the offense of driving while licensed invalid in violation of condition number 1.
How do you put to that, true or not true?
We'll waive the remaining violated conditions.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, and sentence you up to 8 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court is going to find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's to grant the motion to the revoke and sentence him to 2 years in TDC, Your Honor.
All right.
That's our agreement, Judge. We're just asking the court to follow it.
All right. The court is going to find you guilty. The court is going to sentence you to 3 years in the prison. The court will give you credit for any time served, and the court is going to ask for the therapeutic community. Are there any other credit he would receive?
He wouldn't, Judge, but I believe the agreement was for 2 years. I know the court does not have to follow the agreement. But we would just ask the court to follow the recommendation of 2 years if possible. But there's no other time he would be getting.
Judge,
He did successfully complete SATIV. There was 2 timeframes, one for 119 days and one for 42 days.
All right, the court will give him credit for any inpatient treatment that was successfully completed. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because this was not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates in the as it relates to the allegations in the motion. All right, we can go off the record. Mr. Mulkey,
Yes, ma'am.
I see that this motion to revoke wasn't signed by the court. It was signed by Judge Flynn, which means that you were in felony drug court.
Yes, ma'am.
You're gonna have to do better. Otherwise, the last time you use may be the last time you use. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thanks, Judge.
Talk to you. Just actually got the other eye. Thanks.
What is it?
County Court 2.
Who's here on Freddie Guardo?
I am good. Ready or not?
All right, where are we on discovery?
Your Honor, we have a draft of an agreed protective order for CPS, Your Honor. So once I give that to the paralegals, they'll be able to drop a copy for counsel, meaning we already have the records. We'll just get them a copy. And then I've provided counsel the contact information with the advocate so they can view the forensic at the DA's office.
All right, and that's the total of the discovery?
It should be in good shape.
Yeah, I think that'll get us the stuff that we don't have access to as of today.
All right. And were you able to tender an offer or no?
No, Your Honor.
All right, so Ms. Ferguson, recall this in 30 days. Within 30 days, state you need to be prepared to tender an offer, and then it's going to be a quick turnaround for a plea deadline date.
July
Thank you.
16th.
All right, July 16th.
Awesome. Thank you. Thank you for
Thank you.
signing. We appreciate it.
All right, who's here on Corian Valant? Court is calling 2024 CR 3101A, State of Texas versus Corian Valant. Could I have parties announced for the record for the state?
Jason Gary, Your Honor.
Defense?
Scott McComb for Ms. Valent.
And are you Ms. Valant?
Yes,
How do you pronounce your last name?
it's Belen.
Valent.
Yeah, and the first
We're
name.
all
Sorry,
wrong.
Judge.
The whole name though.
All right, and how do you pronounce your first name?
Green.
Kareem.
Yes.
Doubly wrong. Kareem Valent.
Yes.
Okay. Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
Ms. Valent, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the habitual and proceeding actually on the reduced charge of robbery.
Any objections?
No objection.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of robbery? The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
I'm sorry, you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Valent, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of robbery. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the document? Well, did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense of robbery, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all this attachment.
No objection.
All right, state, you may continue to confirm.
Thank you, Judge.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibit 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court is finding you guilty. The court will follow your agreement, sentence you to 3 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Damian J. Galvan or Rebecca Jean Alvarez. Anything else with regards to sentencing?
No, Your Honor.
Did you review what's entitled trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes.
And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to start making better decisions. You understand? All right, good luck to you.
Thank you, Judge.
Thank you. All right, can I see the file on Soto Victorino, please? And also, if I can see the file on a George Abaye. Mhm. All right, Norma, on Victor Santorino, is that attorney still on vacation?
No, he's actually picking a jury in impact court, judge.
All right, so what we're gonna do is, let's recall this. What is he trying in impact?
I have no, he didn't tell me.
All right, so let's recall this into, well, what are the other cases the co-defendant said?
Let me check.
And we can put it on the same date as the co-defendant. And everyone, as soon as lunch arrives for the jurors, that's when we're going to take our recess.
Hold on, I'm sorry.
110 Camacho. Wait.
One of them was already sentenced, Judge, so I'm trying to look for the other one. Okay.
Are you sure one was already sentenced?
Yes, it looks like two of them are.
No, because this is the one where we're waiting for the transcripts of the records. The other two are Raphael Leo's client
Yes, that one.
and also, what is her name?
On Raphael's client, it says sentence.
No, that system is incorrect.
Okay. Which one? Yes, it's 13 years.
No, he was never sentenced.
Says on November 13th, 23. Let me pull up his, I can still pull up 360. So let's see the 360.
Because let me ask you, is the well, let me correct that. Is the co-defendant? Oh, the co-defendants for this, is it Fräulein Guzman?
No, this is a different one.
Ah, okay, then the system has not failed us.
Let me, there's so many co-defendants on here, Judge, let me just run and look.
Okay. Yes.
I have to go back. Now I should.
You are.
Thank you.
Chastity Natal, is she in custody? Chastity Natal?
I don't know. But it's gonna be a lot. I can tell you that, it's gonna be a lot.
Let's see the following Chastity Natal.
Yes, ma'am. Judge, all of them, all the other co-defendants, he's the only one that's pending.
Okay, all right, then what we'll do is we'll give it a 2-week reset since he's in jury trial. All right, Ms. Natal, the state has decided to dismiss your case. So here's the thing, whatever brought you here, make sure it doesn't happen again or it doesn't bring you back, you understand? Because the reason for the dismissal that they're giving is a witness is missing. You understand? All right, good luck to you.
Judge, and the other one, I can do it for July 1st. The 2 weeks lands on June 30th, which is a Sunday.
Just a second. My entire system went down. And what date are you saying?
I said July 1st, because the 2 weeks lands exactly on June 30th.
Okay. Oh, you know what, Norma? Can you put it out just? Because has this attorney always been on this?
No.
All right, so let's put it out just a little bit more to give him some more time.
Different. Do you want to do a 30-day or that's too long?
Let's do 3 weeks.
3 weeks, 3 weeks is gonna put me in July 6th. Which is a Saturday, we can do July 8th.
All right, let's do July 8th.
Okay. You can send. Take me back on July 8th.
All right, State Soto Victorino is being reset for July 8th. Defense counsel is in jury trial.
Virginia's sitting out, she's interested in one for the date for her.
Is that for today? Oh, yeah.
Yes.
Let me do this. You think you did it?
And you look it over, I know you were asking about Chavez, why he was set for today. I think he's set for a violation.
Okay. All right, and his attorney is in trial. So on that one, Norma, let's recall that for next week. Since his attorney is in jury trial.
I can do June 27th.
All right, could I see the file on Sergio Chavez, please?
Yeah. I think it's a lot of pizza.
Virginia Serna?
Present, Your Honor.
Yes. All right, Norma, on this one, they need a jury trial date.
Okay. So you're looking at my calendar.
I got my calendar, you tell me.
And is this criminal trial division?
It would be criminal trial division, yes.
Hi, Ms. Boyd.
Hello.
How are you doing?
All right, how are you doing?
I'm doing good, thank you.
I'm great. We're gonna try to get you a jury trial as quickly as possible.
Yes, ma'am.
Thank you, Judge.
You're welcome. Your attorney is currently in a trial. so-
Yes.
Judge, earliest I can do it is August 6th.
Oh, no.
All right, August 6th, that's the earliest. And let me just tell you the reason why. I'm only one person and there are other cases that are older than yours, so they go first. But if something were to come up and we're able to get to you sooner than that, then we most definitely would try to do that.
August 6th?
Yes.
And Judge, I'll check back in with the court and see how your schedule's looking for CTV trials. You know, this early 2-3 weeks, I'll check back with y'all.
Okay, thank
This
you.
way she knows, you know. If we can squeeze you in, the court may grant us that, so.
All right, criminal trial division, Virginia Cerner.
Is it also from college?
Yes.
Oh,
That's
Virginia
alias.
Cerner, Virginia Gonzalez, which page?
She's on page 4, Judge.
All right, so we're gonna be calling her back for jury trial on August 6th.
Thank you, Judge.
Thank you, Ms. Boyd.
You're welcome. And who is here on? Oh, Michael, you also have Anita Herrera.
Yes, Judge. I don't know. The case. Oh.
Let me see the file on Renee Cantu. All right, thank you.
Let me switch over here.
I'll look you up in a minute. Just give me just a few minutes on this.
All right, Mr. Cantu, come forward.
Morning, afternoon, Your Honor.
Afternoon. So here's the thing. Don't send a message to the court with profanity in it. Number one, your case is set on the day it's set. The person who you need to perhaps send that to is the person who is not here.
Correct.
Do you unfold your arms? So don't do that. One, you need to speak to your attorney and your attorney needs to be here. This case has been set numerous times waiting for your attorney. So the fact that you have what you put in your letter, I have bills to pay. I'm not a scrub.
Correct.
I have my own house and car now and have to pay the bills.
That's correct.
That's who you need. You need to be sending that to your attorney.
Which
not
I
the
have,
court.
which I have.
And there's nothing I can do with that.
And then you sending me here every day, every day.
Yeah.
How am I gonna pay bills?
Yeah.
You say this is
You
a
need
place
to-
of
here's the thing.
communication.
Well, here's the communication. You need to talk to your attorney because guess what? The court schedule doesn't revolve around your attorney. It doesn't revolve around you.
And not
This
to be rude or
case-
anything, but
here's the
he
thing.
doesn't revolve around you.
This
Either
case-
he has stuff to do, he has
Okay.
federal inmates out of
Yeah.
county.
All
I
right,
can't
so-
make him. I tried.
All
I
right,
tried.
so this is what we're gonna do. Oh, we're gonna wait for his attorney. Okay, thank you.
May I be excused or?
Yeah, we're waiting for your attorney.
Okay. He's not gonna show up till the third.
No, Norman sent an email to his
I did.
people, his office to let him know he needs to be here.
I believe he's in Guadalupe County today and another county, I don't know which county.
In alphabetical order, Bear comes before all of those counties.
Your Honor, may I approach briefly?
Yes.
Monica's client, Clemson Camacho, we worked out a plea offer. Do we still have time to do that this afternoon?
Sure. If you all get the paperwork together, we'll do it.
When are you breaking?
Oh, we're waiting until they,
Buzz or something?
yes.
Okay, okay.
We're not gonna come on the agreement.
All right, Anita Herrera.
He's coming, Your Honor.
Sure.
So Judge, to give the court an update, we have a plea offer on the table. We're not gonna be able to come to an agreement today. We will set it for whatever the court wants to set it for.
All right, how long do y'all expect this jury trial to last?
Judge, I believe there's 3 separate instances, so it'd be separate cases.
Yeah.
And I can't remember off the top of my head, but I'd imagine 3 days, Your Honor.
That's about right, Judge.
Ms. Ferguson, can I have a jury trial date on Anita Herrera?
Yes. Ma'am. I can do the same day, Judge, August 6th.
All right, so we'll bring you back on August 6th. You'll be brought over dressed in whatever clothing you're arrested in. If you wish to be attired in something different, you have to do a clothing exchange. Counsel, if there's an issue with either of your clients in regards to clothing exchange, just let the court know.
Okay, Judge.
All
Thank
right,
you.
thank you.
Thank you, Judge. What do you use this? Yeah.
Deputy Mejia. Whenever you get the chance, could you bring out Mr. Martinez so we can put something on the record? Thank you. You can mute us. Yes. Bowie? All right, and you're all pleading on two cases, correct?
Sure.
All right. Court is going to call 2023 CR 8725 and 2023 CR 8727, State of Texas versus Terrence Bowie Jr. Could I have parties announced for the record for the state? Defense?
Scott McCoy for Mr. Bowie.
All right. Are you Mr. Bowie?
Yes, ma'am.
Counsel, have you received all the discovery in each of these cause numbers and did you review it with your client?
Yes, I have and I did.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Bowie, did you review the documents entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in each cause number, or are you proceeding on the indictment as presented? Okay. And the cause number ending in 8727, it appears that you're proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. Is that correct?
That is correct, Your Honor.
And in the cause number ending in 25, it appears that you're proceeding on count 2. Is that correct?
Yes, Your Honor. Yes.
All right. And counsel, the court knows that you're not the party who put the plea paperwork together.
They didn't follow my guidance on writing it down, so
All right.
that will be talked about.
All right, Mr. Bowie. I'm sorry, counsel, do you have any objections to the state proceeding on the lesser included offense and waiving counts in each of the indictments?
No objection.
All right. Mr. Bowie, did you review the documents entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions in each of the cause numbers? With your attorney, did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 27, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1 gram to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 25, the state is proceeding on the possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement in each of these cause numbers, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And that you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your probation were revoked, the court could find you guilty? And in the cause number ending in 25, the court could sentence you up to 20 years in prison. And in the cause number ending in 27, the court could sentence you up to 10 years in prison. And in each cause number, the court could sentence you up to a $10,000 fine as well. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense in each cause number?
Yes, I do.
Mr. Bowie, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Silent on your applications. The cases will run concurrent and they'll take in consideration 2023 CR 8726